All right, everybody, I'd like to get started. So thank you all for being here. Really great day and really great symposium that we're going to have today. First, I want to introduce myself. My name is Denley Wenner. I'm the editor-in-chief for the Journal of Law and Public Policy, and I'm really excited to present this exciting yet relevant topic regarding the current state of affairs today, which is the rule of law. It is a principle that's seen increased discussion in recent days. It's one of the most persistent yet contested principles of democratic governance, domestically and internationally. While various concepts and understandings of the rule of law remain contested, it's critical to build an informed understanding of what the rule should and can look like, and how it can be made effective today. This symposium will explore the rule of law through a variety of contexts, ranging from constitutional interpretation, the rule of law derived from Shakespeare, and litigation around celebrity and public image. The symposium will feature a keynote address and panel discussions exploring the evolving role of the rule of law. We look forward to having a productive day of discussion regarding this critical topic. And before I begin, I'd like to give a couple thanks. First, I'd like to thank all of our speakers for coming here today, both in person and virtually. We greatly appreciate your support for our journal. Second, I'd like to thank the academic advisors for our journal, Dr. Reed, Professor Cornell. You guys have been greatly helpful for us to be able to function as a journal. And additionally, I'd like to thank Dean Kelly for providing us great support as a journal and leading us into a great direction. And then finally, I'd like to thank all of the JLPP members who are in attendance today. You guys are a wonderful contribution, and you guys shape the public policy that will lead us into a brighter future. So with that, I'd like to pass it over to Dean Kelly, who will provide a quick introduction for the symposium.
Thank you, Denley, and thank you everyone for joining. I'm Dan Kelly. I serve as Dean and Mengler Chair in Law here at the University of St. Thomas School of Law. First off, welcome to everyone, especially our guests, all the distinguished speakers and participants. Want to give a special thanks to all the students who have worked so hard to make this possible. The board, Denley as editor-in-chief, our symposium editors, Anna Larson and Jackie Moyne, and just all the students who put in so much time. I also want to second Denley thanks to both Professor Chuck Reed, who has been thinking about and visualizing and putting together this symposium for many, many months, as well as Professor Jenny Cornell. We have a great group of speakers assembled here today. The only brief opening comment I want to make before we turn it over to our experts is that the rule of law is one of those topics that's both timely and timeless. And by timeless, we can go back many, many centuries, and I'm going to invoke the classic movie Legally Blonde. Because in Legally Blonde, one of the key lines, there are many key lines in that movie, but one of the key lines is when the professor, and then during her commencement speech, Elle Woods quotes Aristotle to say that law is reason free from passion. Elle Woods actually takes issue with that, for those who remember the movie, and says that passion, as well as courage of conviction and faith in people, is important to the law. Moving forward several centuries, some of you on your way in our courtyard may have noticed that the class of 2017 in the University of St. Thomas School of Law gave a gift, and it's a plaque with a quote from St. Thomas Aquinas. And Aquinas, building on Aristotle, defined law as a, quote, ordinance of reason for the common good, made by him who has care of the community. There's a lot to unpack there, including what is an ordinance and its relation to the word order. What do we mean by reason? What do we mean by the common good? Who has the care of the community, and how do we find the community? Fast forwarding a couple more centuries, and here's where the rule of law, I think, really comes in. Aquinas wasn't thinking about separation of powers. We had to wait until Montesquieu to think about the importance of separation of powers and checks and balances, the executive, legislative, and judicial branch. But obviously, Montesquieu had a huge influence on the founding fathers and the Constitution. And so as we think about the rule of law today, but also through the centuries, we can come back to some critical issues that I know we'll examine in terms of who has the care for the community, how do we find the common good, what do we mean by an ordinance of reason? And going back to Aquinas, there are also several levels, according to Aquinas, of law, starting with the positive law, including statutes, but also including the natural law, which has a great tradition at this law school, and seminal thinkers from Augustine to Martin Luther King Jr. have talked about an unjust law not being a law at all, as well as the divine and eternal law. So I know there's going to be a lot of topics today, from technology and history, corruption, sovereignty, thinking about the human condition, and thinking about constitutional governance. So I'm just so pleased that the University of St. Thomas is able to host this symposium, and I'll turn it over to Professor Chuck Reed to get things started. So thank you very much, Chuck.
Dean Kelly, thank you for those eloquent remarks. And I will just mention a few items that you may look at the program. You look at the program, and we see this morning, we see talks on national security, we see talks on celebrity and on artificial intelligence. You may ask, what is the connection between these three presentations? And I will submit the connection, the essential connection, is humanity. What we're seeing with each of our presenters, Professor Kevin Lee will be addressing the issue of artificial intelligence and the place and role for humanity within the rule of law as we watch the ever-increasing pace of development of artificial intelligence. Professor Davidson will be talking about celebrity, image and likeness, these sorts of issues as they pertain to the music industry, the entertainment industry. But beneath that is another essential attribute of what it means to be human, and that is the creative process. And then finally, Professor Rudisil will be talking about something that is, again, one of the most awesome elements of what it means to be human, and that's a sense of responsibility, a sense of duty. In the particular focus of his talk, it will be on armed forces and national security. But again, we're connected. Each of these presenters are connected by a common thread that emphasizes the centrality of the human person and law. So we'll begin with Professor Kevin Lee.
I don't think I can top Dr. Reed's introduction, but I will go more specifically into the panel introduction. So good morning and welcome. My name is Blair Kirby, a senior editor at the University of St. Thomas Journal of Law and Public Policy. I am honored to introduce our distinguished panel of speakers, Professor Kevin Lee, Professor Jane Davidson, and Professor Dakota Rudisil. Our first professor, Kevin Lee, will discuss the information revolution and the fate of the rule of law. Professor Kevin Lee teaches at North Carolina Central University School of Law after serving 15 years as a tenured professor at Campbell University, where he founded the Campbell Law Innovation Institute and chaired the North Carolina Bar Association's Future of Law Committee. He has practiced in Tokyo, teaching Japanese law, clerked on the U.S. District Court for the Eastern District of Pennsylvania, and holds advanced degrees in ethics, philosophy, and religion, in addition to his JD from New York Law School. On your tables are selected readings on interdisciplinary topics, kindly provided by Professor Kevin Lee. Please make sure to take a look. Next, we welcome Professor Jane Davidson, who will discuss celebrity, litigating image, and reputation in the public eye. Professor Jane Davidson is a lecturer in music law at the University of Southern California, an attorney at Nolan Hyman, where she practices entertainment law and litigation. A graduate of USC's music industry program and Loyola Law School, she focuses on intellectual property, representing public figures and creative professionals in defamation, right of publicity, trademark, and copyright disputes. She was part of the legal team that successfully ended a 13-year conservatorship for a high-profile artist, In her teaching and scholarship, Davidson blends law, economics, musicology, and ethics to explore how creativity and justice intersect in the entertainment industry. Our third speaker, Professor Dakota Rootsill, will speak about courts, speak the law to the troops. Professor Dakota Rootsill is a professor of law at The Ohio State University Moritz College of Law, where he teaches national security law, legislation, and professional responsibility, and directs a legislation clinic and the Ohio State National Security Simulation. His scholarship on intelligence, secrecy, arms control, and legislation has appeared in leading journals, including the Georgetown Law Journal and Yale Journal of International Law. He has served in all three branches of the federal government, including the U.S. Senate, the Office of the Director of National Intelligence, and as a law clerk to Chief Judge James B. Loken of the Eighth Circuit. Professor Rootsill earned his BA from St. Olaf College and JD from Yale Law. We are grateful to have such a distinguished group with us. Each speaker will offer brief remarks, after which we will move into a moderated discussion and an audience Q&A. Please join me in welcoming our speakers, Professor Kevin Lee, Professor Jane Davidson, and Professor Dakota Rootsill.
There you go. Thank you, Blair. Let me start my clock. There you go. Well, thank you. Good morning, and thank you for coming to this early morning talk. I know it's early, but I think the topics are very important. And in fact, I hope that you will agree that the foundational concerns that I'll raise might set a theme for some of the talks for the conference. And I know that's a bold claim, so let me show you why I believe it to be true. I want to start with a simple claim. We are trying to make the rule of law work in a world for which it was not designed. This isn't because people became worse or due to liberalism or populism, but because the background picture of the human person that underwrote our legal theories has shifted under the pressure of information science. Luciano Floridi, director of Yale's AI Ethics Center, calls this shift the fourth revolution. Let me begin with that. Floridi tells us a familiar story of three great human decenterings. Copernicus, who showed us that we are not the center of the cosmos. Darwin, whose evolutionary theory shows that we are not the center of creation. And Freud's psychology, which shows that the I is not the center of the mind. Floridi argues that we are now in a fourth revolution, digital information, which shows that we are not the sole locus of intelligence or information processing. We inhabit what he calls an infosphere, in which we are inforks, just one kind of informational organism, among others. This information revolution has decentered our moral anthropology, suggesting a new metaphysics he calls informational structural realism. This new reality has shaken the traditional picture of the human subject as a unique, rational individual possessing knowledge and agency. The traditional view is no longer compatible with the scientific worldview, and yet our legal theories assume nothing has changed. I think the rule of law must evolve. The classical rule of law rejects governance by the unconstrained will of rulers. It promises a stable human reason that is public and contestable. The idea was born in many places, but found expression in a famous confrontation in the 1607 case known as Prohibition's Delroy. King James I, a believer in the divine right of kings, asserted that he could personally decide legal cases in his courts. He argued, "I thought that law was founded upon reason, and I and others have reason, as well as judges." Sir Edward Coke, the Chief Justice at the time, had to tell the king no. Coke's reply was, "The king was correct. Law is reason, but it is not natural reason. It is the artificial reason of law, a disciplined judgment refined by long study, experience, and practice. He told the king that the law was the golden Metuanan measure that protected the subjects. This established the principle that even the king is under God and the law. By the 20th century, Cook's artificial reason was understood differently by diverse theorists like Lon Fuller and Joseph Raz. Fuller described the inner morality of law, formal requirements like generality, transparency, prospectivity, clarity, stability, and congruence. Raz argued the rule of law is instrumental. Its value is making power predictable and non-arbitrary so people can plan their lives. This picture, however, rests on several common assumptions. The rule of law is commonly held to rest on three claims. Law addresses stable individual persons. These persons are knowable to themselves, can understand their reasons, plan their lives, and exercise free will. Law is something that speaks to them and so they can respond. This picture is fundamentally anthropocentric. It's about intentional agents possessing free will and constrained by social norms. The rule of law as a political ideal rests heavily on that picture. The traditional view of the rule of law relies on certain epistemic and ontological presuppositions. First, the epistemic transparency of power. Officials and citizens can, in principle, know the law. They have a shared factual world. They inhabit a common reality where reasons and evidence function. They are unitary, intelligible subjects. That is to say, the law addresses coherent persons, not fragmented data profiles. And finally, the system is regulated by a human-centered reason. The artificial reason of law is still the reason of human interpreters. In short, the rule of law is an epistemic and moral pact run by institutions in a way that are knowable, reliable, and contestable by the humans they bind. Under the informational turn, however, reality looks quite different. Ontologically, we live in an infosphere. Our identities are increasingly informationally constituted by credit scores, risk scores, and social graphs. Epistemologically, knowledge is not just in our heads or in books, but embodied in the information systems, including machine learning models. While we are still persons, in governance, we are often treated as profiles and data patterns. The artificial reason of institutions is increasingly implemented in code. It is no longer the exclusive province of legal elites. This leads to a central question. What becomes of the rule of law when Cook's so-called artificial reason is outsourced to systems no one fully understands and that treat us as data points, not as discursive agents of free will? Let me name three pressures. First, opacity, which I call the problem of inscrutable risk. Machine learning systems can be empirically powerful and yet also epistemologically opaque. A model can deny you credit, but the explanation is often just the model learned this from a pattern of data. That is a statistical fact. It's not a legal justification. This inscrutable risk undercuts the law's promise of public openness and clarity. Second, these systems aggregate into what might be called pattern-based governance. Classically, officials apply rules to facts and give reasons. In many informational systems, we optimize a loss function over populations, not individuals. This shifts governance from individualized justification, why was this decision about me, right, to population-level optimization. Why is this? This is what models do best overall, right? We become instances of patterns, not addressees of norms. Third, we witness fragmentation in the factual world. Network models show us how echo chambers and filter bubbles can generate stable but false beliefs. We see this in divergent news universes and deep distrust of expertise. The rule of law presumes a shared view of facts, where giving reasons makes sense. In these fragmented infospheres, that assumption fails. If we consider these three pressures together, opacity, optimization, and fragmentation, then we can see how the rule of law's core commitments are strained. Public openness becomes merely a formal gesture when the real governance happens in privately owned commercial models that are concealed both technically and legally from view. Companies like Palantir, which does the data analysis for many government agencies, use such opaque algorithms to analyze public data along with private data from online platforms, private surveillance companies, and even online shopping that sidestep Fourth Amendment protections. Their immigration OS is used by ICE to round up suspects, but makes many mistakes. Contestation becomes hollow when you can't argue with a black box model. Even when mistakes are made, the burden falls on citizens to overcome the presumption of guilt cast upon them by a black box that is impenetrable to external view for technical and legal reasons, being owned by a private entity. The guidance function of law is lost because the opaque decision-making algorithms make predictions of the state's power impossible. Law seems like a sort of arbitrary will of the sovereign that Cook feared. The rule of law could degenerate into a rule of models, a regime where power is exercised through systems that are not structurally aligned with our traditional conceptions of law. What would it mean instead to translate the rule of law into informational terms? Here's one way to reframe the law. While traditionally the rule of law constrains arbitrary will, in an information age, it must also constrain arbitrary informational power, the power to collect, infer, classify, and act on information about the person. This suggests we need an informational analogy to the classic rule of law virtues, and I'll sketch 4. First, we should shift the focus from public openness to legible computation. Where systems significantly affect your legal position, you need a right to legible explanations in normative terms. This means understanding the kind of person the system takes you to be and the normative categories being applied, what counts as risk and fraud. This is Fuller's public openness and clarity for machine reasoning. Second, we need a shift from traditional assumptions of the possibility of compliance to a focus on actionable guidance. If models make decisions on patterns you can't anticipate, you're not being guided by the law, you're being sorted and surveilled. We need systems that can show people what they could do differently so they can change their status, right? Or the law could modify constraints on unactionable features. Otherwise, guidance collapses into just statistical fate. Third, we must shift from due process to a right to contest computation. Classic due process involves knowing facts and challenging the decision maker. In an infosphere, this must be extended to contesting data, inferences, and models. This includes a right to a public-facing persona, which is the right of an individual not to be fully visible and public to systems that cannot justify their own norms. Government surveillance, directly or through private means, should be limited to the bounds that leave space for a private life, I believe this is essential for democracy. Finally, we should conceive of separation of powers to include a notion of informational pluralism. Separation of powers historically functions to prevent the concentration of authority. Today, authority is being concentrated into a few private platforms, infrastructures, and models. An informational version would demand a plurality of infrastructures and epistemic authorities, perhaps including an adversarial public auditor, something like a CPA, but for AI ethics, to ensure meaningful public contestation. Let me come back to where I started. Edward Cook insisted that King James I must submit to the artificial reason of the law. We find ourselves now tempted to submit to a different artificial reason, one that is faster, larger scale, and impressively predictive, but often opaque, unaccountable, and privately owned. We face three responses. A technological triumphalism. There's a book you could find out there that talks about legal singularity, the idea that all law could be computational. This was presented at AALS last year. I was quite surprised by it. This is believing that data governance is perfecting the rule of law. Reactionary nostalgia would be another, just let's reject all of this and go back to the politics of ethic virtue. That's probably not possible. And then three, a reconstruction, taking the implications of information science seriously while insisting that legible guidance, contestation, and constraint be put on the powers that are otherwise non-negotiable. I'm arguing for the third. In closing, what I have argued today is only the beginning of a larger project. The information revolution has not merely disrupted our technologies, it has unsettled our ontology and epistemology and our understanding of our moral lives. It has altered the foundations on which the rule of law and democratic polity once stood and placed us in a world that our legal and political institutions are not yet prepared to address. For several years now, I've been tracing this transformation, beginning with the collapse of philosophy in the 20th century, moving through the rise of a managerial university and culminating with what I call the computational sovereign. What I see increasingly is that the future of the rule of law depends on whether we can develop a new philosophy of the human person adequate to the informational age. It must be one that does not retreat to nostalgia or submit to technological determinism. It must insist that democratic judgment, human dignity, and a right to contestation remain possible. This talk is drawn from a larger manuscript I'm completing and from a public-facing project that I'm launching this year called The Exile, which is linked there on the QR code, where I'll be writing about the deep philosophical shifts. The questions I've raised here will be governing questions in the coming decade. Who is the subject of law? What counts as knowledge? How do we hold institutions accountable when their power is informational and not physical? And what becomes of the human person when the public reason of governance is increasingly written in inaccessible computer code? I hope to continue the conversation, and I hope you'll follow me on my Substack. Thank you.
Hello, everyone. Shockingly, despite the fact that I thought that my presentation seemed extremely different from everyone else's, I think there are many things that tie directly to what Professor Lee just said, so I'm very excited to share that with you. So I am currently in full-time law practice in entertainment litigation, while also a part-time lecturer at USC. So part of the reason why I'm engaging in this research is in an endeavor to seek out a future law professor career and to be seen as a legitimate scholar. So for that reason, of course, I focused on celebrities and social media, which are seemingly the least scholarly types of topics. So the question is, why celebrities? Why do we care about the rule of law when we're looking at how celebrities are perceived on social media? And the key issue here is that a celebrity whose brand, whose face, whose reputation is showcased across a variety of social media platforms where all of us engage with them and perhaps engage in runaway conspiracy theories about what they're doing behind closed doors exists at the intersection of legal protection and platform exploitation. So as you heard from Professor Lee, now we're navigating the wild west of social media and all these information platforms where that oftentimes dictates our reality, even if that's not actually the case. So also in the context of celebrities, there is a significant value to the person's brand and reputation and how that actually is not only part of their own self and humanity, but also potentially billion-dollar brands. So when we look especially at defamation actions, which is what I'm going to be focused on today, you can start to see where issues can arise when we're looking at the idea of, for example, New York Times versus Sullivan and how we change the standard of how we look at public figures when statements are made about them online, and how that sometimes can end up with a question of, do we care more so about different types of speech and the format in which it is given? So one of the issues that has been brought up most recently by Supreme Court Justice Neil Gorsuch is this concept of cheap speech on social media. So when we look at, for example, a publication in a prominent journal of the New York Times, of the Wall Street Journal, of anything that is well-researched, fact-based publications. Oftentimes we see that of this is a vital right that we need to protect, that we need to make sure that we have this open conversation, and if for some reason they get the story wrong, despite all those efforts, we still want to protect them against defamation action. And in the words of Taylor Swift, however, if you say it in a tweet, that's a cop-out, meaning that you say, I am stating this information and I don't care whether or not it is true, I am simply going to post it and send it off into the ether. Now, oftentimes, those things can run away and end up with memes, all sorts of things that are perhaps maybe seen as parody or something that isn't actionable, but oftentimes become something that people perceive as the truth. On the flip side of this concern is the concept of expensive litigation, meaning that if you are sued for defaming somebody, which happens all the time, there are many celebrities in my practice and other types of public figures who oftentimes will engage with defamation actions with all types of speakers, including random people who say things about them on the internet, including clear scams that are oftentimes trying to sell products utilizing that celebrity's name without permission. Or you could even have them contacting legitimate publications, asking them not to publish articles and accusing them of defamation. Now, the key issue with expensive litigation is if you receive that letter and if what you are saying is true, or at least is something that we should allow in our scope of First Amendment protected speech, then the threat of expensive litigation oftentimes will prevent somebody from going forward with that speech. So the issue here is we have to balance what is the truth and encouraging the truth while also encouraging what they call breathing space in our public dialogue. So there are a couple on this chart, a couple of different topics that are looked at when it comes to outcomes in defamation cases, but there are also many that I have added on here that you may not have seen before. For example, you'll see algorithms, which was just mentioned by Professor Lee. So now we have platforms and algorithms that are pushing certain types of articles into somebody's feed and encouraging certain types of speech, even if it is false. And we know that to be true. Reuters just did an investigation of Meta's policies and how their algorithm works, and found that they actually push forward many scam advertisements that feature, for example, celebrities. They might say, like, this person took this pill and lost all this weight, and you have a picture of a celebrity who didn't take that pill, and that was just a random picture of them, and maybe they were taking something else, but we don't know. Those are actually pushed by the algorithm because they are making so much money off of that advertising content. So this is something that is oftentimes encouraged by platforms. We also want to think about visibility. So, who is seeing these posts? What is the opportunity you have to remove the defamatory content? And how far and rapidly is it spreading before you have a chance to counter that narrative? And then, of course, the resources that are available to a defendant in order to be able to assert their right to free speech. Everything on the other side are within the scope of what we already see in defamation context. So looking at the scholarship in this area, I'm highlighting two quotes that fit with this cheap speech versus expensive litigation concept. So from Professor Lidsky says, today's defamation law remains so complex, the common law of defamation has not adapted adequately to the challenges posed by cheap speech in the digital era. And Professor Sanders says, the goal of a SLAPP suit is not to win on the merits, but rather to discourage defendants' right to free speech through the prospect of ruinously expensive litigation. So going through a couple of examples, first is a defamation case filed by Cardi B. In this case, an internet blogger or vlogger / podcaster stated many times in repeated YouTube videos, podcast episodes, social media posts, that Cardi B was a prostitute, that she had several STDs, that she did cocaine, that she was a criminal, many types of things that you would not want someone to say about you, especially if they are not true. And she amplified this across social media and it framed it as exclusive inside information rather than obvious parody. She also admitted in the trial that she continued to publish despite doubts of the truth and warnings. So the action in Northern District of Georgia resulted in a $4 million damages in favor of Cardi B. And Tasha K appealed to the 11th Circuit, and they found that there was sufficient evidence of actual malice. So in this case, and there's a great law review article on this topic, by Professor McNeely, where basically we're looking at a situation where we have gossip, which I would qualify potentially as cheap speech, but this also standard of verification failures, meaning that because of the quick turnaround and what's going to get you clicks and what's going to get people engaging with your site, there's actually an incentive not to spend the time to verify the statements that you are making. On the opposite end of the spectrum, we have the action that Dave Portnoy brought against Insider. Insider posted on their paywalled website an article accusing Dave Portnoy of sexual misconduct and engaging in violent and humiliating sexual encounters. Dave Portnoy immediately began engaging in a counter campaign across his social media platforms. In his lawsuit, he alleged $12 million of damages, and he said that he lost advertisers and an audience on his Barstool Sports platforms because of these allegedly false claims. However, the court did not agree in this case, and part of the issue here is that there was actually evidence. Now, again, he was able to present his counter-narrative, which also included evidence. Insider received multiple screenshots, interviews with people who claimed that they had engaged with him on these subjects. But when we looked at the standard of whether or not there was actual malice, they didn't say that they had to continue to try to find any sort of counter-narrative or to show that it was actually false. And what's interesting to me here is that although there was no remedy at law, I think that was honestly okay for him, even if it was not true, because as a public figure, Portnoy has this ability to counter the narrative that is being put forth against him because he has this public platform. Another widely publicized case is the Amber Heard versus Johnny Depp case. Here, again, the virality of the statements made by Ms. Heard were perpetuated by them going viral on social media. We also saw this happen during the trial, where it seemed that the audience flipped on which side they were supporting after seeing the evidence at trial, which essentially, was the overall concept of people watching litigation and trying to make their own decisions, maybe with not knowing how the law applies, really influences, again, how your overall reputation is perceived, regardless of the outcome of the trial. Now, looking at the defamatory statements, I find extremely interesting. So specifically, the statements at issue for Ms. Heard was that in an op-ed that she posted, she stated, "I spoke up against sexual violence, faced our culture's wrath. That has to change. Then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. I had the rare vantage point of seeing in real time how institutions protect men accused of abuse." Now, you'll notice in each of these statements, she's not actually making specific statements about Mr. Depp. However, Johnny Depp did prevail on this claim, and the jury instructions in this case specifically said to consider the statements in context of the op-ed as a whole and the overall narrative surrounding the op-ed. So that's something that you don't necessarily see in the coverage of this, and it was just upheld on appeal. So the jury instructions were not, I don't know if they challenged them in the appeal, but the other issues that they appealed were shot down by the appellate court. But what's interesting here is this asked us to look at the full context and not just the statements on their own, because the statements on their own probably don't rise to the level of defamation, but with the context of everyone knowing that the person she was speaking out about was Mr. Depp, then that was something that led them to the conclusion that it was defamation. Now, even the President of the United States oftentimes engages in defamation litigation. In fact, at the law firm that I work at, there are many attorneys who previously worked at the law firm that represented the Trump family in all of their defamation actions. So I've kind of had a front row seat to that, even though I don't personally represent him or his family. But what's interesting, if you look at the two most high-profile defamation actions regarding President Trump, we have Stormy Daniels and we have E. Jean Carroll. And these are almost the exact same type of statements and almost the exact same context that President Trump is making about these two women. In both situations, he's accusing them of being con artists, scammers, using language like that, which is what the alleged defamatory language was. He also accuses them, for example, of lying about sexual encounters, and oftentimes that is what is focused on in the narrative, but that's really not what was at issue primarily in the defamation claims. So if we look at the language, in one case we have, in the Stormy Daniels case, it was found to not be defamatory. She lost the anti-SLAPP motion in that case. But the difference in the Jean Carroll, and I know that's probably hard to read, but you can look this up, is that he engaged on a much more prolific campaign in this case. He made repeated statements that she was lying, that she was scamming him, and made these official-looking statements. So again, here the court looks more at the overall context of the campaign that's happening across various different social media platforms, rather than what the isolated statement is, which was typically how we would look at it. We also see that platforms are not exactly protecting against this type of thing. So for example, when Elon Musk took over Twitter, now X, verification completely destabilized. You could now pay, and you still can pay, for verification, and many people took advantage of this by creating verified accounts of different brands, of different celebrities. So for example, this looks like the Chiquita Banana Company has just overthrown the Brazilian government. And the way that this was addressed was, in fact, also by a tweet. So immediately, Elon Musk was able to change the official policy of this massive platform with essentially everyone on it. I know not everyone is on it, but it feels like everyone's on it. And he says, going forward, any Twitter handles engaging in impersonation without clearly specifying parody will be permanently suspended. So with just one tweet, he completely reverses the policy of the platform. Meanwhile, someone created an account impersonating Elon Musk and says, changed my mind, impersonating accounts is legal again, have at it, this is a parody. So the platform architecture itself really does matter, because when we look at, as Professor Lee mentioned, the spaces and the people that are being regulated by the law, now in our current environment, much of the speech that is occurring is happening on these extremely powerful platforms. So that's sort of where I have ended up going with this paper, is focusing specifically on celebrities on social media platform context rather than as a whole. And the reason why this matters is because the algorithm actually amplifies false narratives and they go viral, because false speech is profitable. And this also collides with a bunch of significant current legal issues. As I mentioned, there are oftentimes scam ads using celebrity likeness, and specifically a big issue right now, which is something that is being addressed by Congress with the No AI Fraud and No Fakes Act, to trying to address the issue of right of publicity when it comes to deepfake endorsements. There's also the question of what is the extent of Section 230 limitation of liability on these platforms. Specifically in the case Anderson v. TikTok, which dealt with a dangerous trend that happened on social media, where TikTok was actually pushing videos to children, encouraging them to choke themselves until they blacked out with various different items. And in that case, originally the lower court said that there was no platform liability due to Section 230. However, on appeal, it was found that although as a publisher, they would not have liability, for example, for a defamation action, but in the context of the algorithm itself and the algorithm causing potentially tortious issues, that was held to be potentially an actionable issue, and then was sent back down to the lower court. So this is important because it suggests that we do need to put some kind of pressure on these platforms to make sure that their algorithms are in fact aligned with the law and are not creating a situation that is inherently dangerous. I mentioned before that Justice Gorsuch addressed some of these issues and has encouraged potentially a change in this. And I don't often agree with Justice Gorsuch, but I do on a lot of these issues, although it also suggests some of the possible caveats to this. So this is in the Berisha versus Lawson dissent. And he says, it seems that publishing without investigation, fact-checking, or editing has become the optimal legal strategy. The disruption of disinformation, which costs almost nothing to generate, has become a profitable business, while the economic model that supported reporters, fact-checking, and editorial oversight has deeply eroded. Now, private citizens can become public figures on social media overnight. Individuals can be deemed famous because of their notoriety in certain channels of our now highly segmented media, even as they remain unknown to most. So this commentary in the dissent by Justice Gorsuch is meaningful not only because it addresses this issue that, this is a pervasive issue across platforms right now, but it also distinguishes between, again, the cheap speech versus the legitimate speech that is researched and being discussed based off of that fact-checking. However, the problem is how do we change how we look at defamation actions without limiting or chilling speech? And this goes to the concept of breathing space. And in Gertz, the court said that applying actual malice standards to public figures creates the freedoms of speech and press that breathing space essential to their fruitful exercise. Meaning that, if I'm going to be talking about a current issue, about a public figure, about, a matter of public concern, that I should be able to talk about it without completely knowing what I'm talking about, not needing to be fully fact-checked. But that being said, while Gertz gave us the breathing space doctrine, TikTok gave us hyperventilation. Now we have everybody talking about these things without knowing the full context, and oftentimes those are the things that get perpetuated rather than whatever original article or what original statement made with proper foundation, even if it wasn't accurate, was made. So this raises a number of key questions, which I am currently exploring and encourage you to think about as well. The first is, as public figures and publications simultaneously evolve, could New York Times versus Sullivan add a consideration of who is speaking and perhaps of the context? And then when should social media platforms be brought into a case? Do they have too much power in regulating the public square? What changes can be made that simultaneously prevent platforms from turning a blind eye to harmful false content and speech-stifling image management practices? How should a full news story be treated differently than a tweet? Can you be defamatory by saying something or reposting something if you haven't even read the article or just saw a headline? I've had to change my practices in that area of actually making sure I read the article before I share it to make sure it's legit. And does it matter the overall concept where the statements are amplified and associated with additional facts and falsities? So regardless of how much you care as to whether celebrities' images are destroyed online by people who are out to get them or are just simply not fans, this issue can be examined through that lens, and then is going to have broader implications for anybody who potentially becomes a public figure, even in a limited area. Thank you.
Professor Rudisil.
I'm going to speak from here because I think with all the light coming in, I'm not really going to be able to see my laptop or that screen well enough to stay on point, which means I'm just going to speak extemporaneously and probably too long. All right, well, it is just terrific. Okay, we've got the slides. All right, it is just terrific to be with you, and I want to thank my colleagues for their very stimulating presentations. I've been scribbling questions for myself and them that I hope I can ask them either during our Q&A or some other time. So just terrific to be back with you. I'm having these flashbacks to the start of my clerkship on the 8th Circuit when I was here for the investiture of Judge Schiltz. Justice Scalia spoke. He was very entertaining and engaging, and that was almost 20 years ago. And so it's a real treat to be back here in this atrium in what I regard as my first home, which is the state of Minnesota. I'm a happy Buckeye, but I do love Minnesota. So I'm going to be talking today about what I call the title of this is Executive Autocracy versus the Rule of Law. Courts must speak directly to executive branch personnel. I'd been sketching out a blog post, a symposium piece, something like that, and I had that just percolating at exactly the moment your invite came in. So it was perfectly positioned, and I'm excited to talk about this and engage in dialogue with all of you. As mentioned, I work basically in three areas. One is legislation, second is national security law, third is professionalism, the work of professionals in a number of fields, especially in the legal area, and this project is right at the intersection of those and also reflects work I've been doing in recent years on this constitutional moment we're at, and civics and how professionalism and statutes and national security and all that stuff relate to that. There we go. So is there a clicker that sorry, I should have gone and get that. No. That's right. Okay. All right, so I very much appreciate the topic of your symposium, and I applaud you for it, and extend my thanks to those of you on the journal staff who have put this together, and my appreciation to the dean as well for his remarks. As the dean noted, and I think these are pretty much exactly the words I have on my slide here, the rule of law is eternally important and it's timely. It is the central constitutional concept, the rule of law, right? It's all over the Federalist Papers. Constitution says, speaks of the supreme law of the land, right? Rule of law, the central concept for the whole constitutional architecture to work. Everything else in the Constitution depends on the rule of law. Limitation of government power, separation of powers, checks and balances, federalism, individual liberty, elections, the democracy elements, the republic elements in our system, perfection of the union, the common defense, domestic tranquility, prevention of foreign invasion, prevention of war among the states. All of these, what's textually and structurally there, and then what we see in the Federalist Papers for the rationale for the Constitution, all of it depends on the rule of law. The rule of law also sustains our American civic traditions individually, and then together in productive tension with one another. Conservatism, liberalism, progressivism, libertarianism, populism, individualism, communitarianism, values universalism, nationalism, majoritarianism, counter-majoritarianism, right? These are all vital American traditions. We need all of these traditions if we're going to continue to have a country in the future, which is going to be one which is going to promote the perfection of our democracy and our rule of law experiment, right? We need all of these things, and we need all of them together, right? And the rule of law also, if you look at each of these, again, civic traditions we have in America, the rule of law is also central to each of those. So really central to American constitutionalism. Rule of law, eternally important and timely. Also, I think it's been neglected as a concept. I can say that now that I'm 53 years old, and I've seen a number of different decades, and really noted. I even noted it at the time was a declining focus on civics and the Constitution and the rule of law. I would put this down to kind of the peace dividend after the Cold War. More so than a reduction in defense spending, we were just thinking a lot less about civic stuff because Cold War's over, right? Market republics have triumphed. Why do we need to focus on this? Everything's economics, right? Not so much, right? We basically took a civics holiday in this country. The rule of law is under pressure with few precedents at this scale in US history, and it can be hard to discuss today because of our divisions, right? Everything that we've got going on in this country. But I think it's enormously important that we do. And we, as legal professionals, I think are especially well suited to talk about it because of our values commitments to civility, discourse, having difficult conversations, even adversarial conversations, right? We, as lawyers, are especially well suited to talk about the rule of law in this fraught moment. It's hard for me to see what slide is up. Okay. Okay, there we are. I think that's the right one. I apologize. I'm getting a lot of glare. Okay, so as an introductory matter, I just want to say that the latest controversy in our civic space that has exploded in the past 48 hours speaks directly to my project. Of course, I orchestrated it this way. I have access to the source code that's running our simulation, orchestrated this perfectly. So as you may have seen, a number of Democrats in the US Senate and the US House who are military veterans of the US intelligence community, put out a short video speaking directly to executive branch personnel in the field, in the bowels of federal agencies. As Senator Alyssa Slotkin of Michigan wrote here on X, we want to speak directly to members of the military and the intelligence community, right? The American people need you to stand up for our laws and for our Constitution, and the clear, simple message was illegal orders must be refused. Of course, there's been a response, quite a bit of response to this. The president said this is seditious behavior, punishable by death. He reposted a comment about hanging them, saying George Washington would hang those legislators. I'll leave that to the side. Senior White House advisor Stephen Miller said Democrat lawmakers are now openly calling for insurrection. The White House press secretary seemed to kind of walk things back a little bit and clarified yesterday the president does not, in fact, want members of Congress put to death. So it is exactly the type of controversies that we're used to, right? This is exactly the same. Anyway, so lawmakers, right? They're correct on the law, right? Executive branch personnel cannot comply with illegal orders, right? There's no legal basis for it, right? If you do something illegally, right, under color of law, right, like you don't have the legal legitimacy that comes with the power of the law, right, behind you, and you're basically just a private actor at that point. There's no question about that. They have good reason to be concerned about legal compliance, and they have every right to speak to government personnel. Also, I would say this, though, however, the message from these members of Congress was not particular to a particular order or operation that's underway. It does not provide additional guidance to anybody in the field in the executive branch or in the bowels of agencies about how specifically to sort illegal from ambiguous, from clearly legal orders or operations. And I think that Congress is not the only branch that should speak directly to executive branch personnel. So my central claim, let's see. Yeah, I think that, okay. I can't see that. Okay. So my central claim here is that courts, where necessary, should address themselves directly to executive branch personnel in court writings, right? Orders, opinions, whatnot, especially when a court is invalidating or enjoining an action of the executive branch. Why? Number one, significant risk of unlawful orders from this executive in particular. There's always that risk in any context, but especially with this one, for reasons I'll talk about. Second, there's risk that field personnel will not understand the law. Will not understand that a court has ruled, and even if they are aware of a judicial opinion, unless they're lawyers, right? And even then, they may not be able to really, understand this opinion or order that has come down, which, and very often, you read these cases, right? Like they're dozens of pages. Sometimes many of these, these decisions we've seen this year, hundreds of pages. Imagine being somebody in the field conducting operations and a court rules that this is illegal and enjoins it, and you've got a 145-page opinion? Are you kidding me? Can you really expect them to understand that, especially if they're a non-lawyer? It's just, so anyway, very significant risk of that, of the law not having effect for that reason. And then third, risk that politicos in this executive, the president, other appointees, will try to frustrate court orders, potentially citing unsustainable constitutional law theories. All right, my outline, I'm gonna hit a few points here, and then I look forward to our discussion. So the first, thank you. Okay, outline, okay. Okay, all right. So the first thing I want to address is the trajectory of executive autocracy in this country. Obviously, this is an enormously fraught topic. I imagine there are different views on this in this room, as there are in my classrooms and among my friend circles and my colleague circles. That's good. Disagreement in a democracy is a feature. It is not a bug. I will give you my assessment of this as I see it from having studied these issues for a number of years. The first thing I'd note is that the polling data and the anecdotal evidence is pretty clear that the intentions of the Trump team in the executive branch and the president's voters vary a lot when it comes to rule of law. I can look at I would love to dive into this because it's fascinating about, for example, polling data on portions of the electorate that think that, the president, to get things done, should be able to ignore the law, right? Statutes, the Constitution, whatnot. That number is spiking generationally. Spiking versus my Gen X generation, the greatest generation, the boomers, right? When you get to the millennials and especially the Xers, spiking hard, right? For example, 43% of Gen Z men say that the president, to get things done, should be able to disregard the Constitution. 43%, right? For my generation, it's 6%, right? Vast, right? So there's a change going on. However, when you look at the data, and talking to the many people I know who are serving in the administration, many of whom are just beloved former students of mine, a wide range of views, I think, actually within the Trump coalition about rule of law issues and whatnot. I would also say, however, that this administration this year is generating massive evidence to corroborate the theory that it's seeking executive autocracy, which is a warping of the constitutional system in favor of essentially unlimited presidential discretion and total subordination of personnel within the executive branch. Abundant violations of facial violations of the law on a scale that, certainly in my career I've never seen. Executive crushing of agencies built over many decades via dozens and dozens of statutes. The handling of TikTok is completely divorced from the statute and the law. immigration cases, mobilization of the federal military, conduct of military and ICE forces in the field, and now the strikes on drug smugglers, which under the conventional understandings of the law are just murder. Just abundant evidence, I'd say, in those directions, right? People can reasonably disagree on a lot of specifics, but I'm just saying the trajectory is, in my view, cannot be ignored. So Ryan Goodman of NYU with a number of colleagues has put together over at Just Security a tracker tracking, oh, I'm sorry, I keep forgetting.
I can just do it for you.
Oh, thank you.
Because I can see your screen.
Okay, thank you. I appreciate it. Very kind of you. This is collegiality. Right? This is a professional ethical duty. I appreciate that. So hard evidence of bad faith, unfortunately, by this executive with regard to courts, defiance of court orders, evasion, false statements to courts, misleading statements to courts. There's just a ton of data of this, right? So, and I would just recommend that, you have a look at that. From a personnel standpoint, decapitation of civil servants in the military, just immediate firings of the Joint Chairman of the Joint Chiefs of Staff and other four-star officers and so many others. Purges and replacements of nonpartisan civil servants, neutralization, especially of accountability institutions, including ethics offices, inspectors general, whatnot. There's just a ton of evidence, right, to support that theory. I recently published a piece with the Journal of National Security Law and Policy that describes and analyzes this trajectory as what I describe as deprofessionalization and de-ethicalization, because these actions taken together, and especially a lot of the directives to professionals of law, arms, and intelligence, one could add weather, science, so many other things, right, runs right up against their professional duties and their common ethical commitments, which I've analyzed in my scholarship, including heightened fidelity to the truth, factual truth, legal truth, retention of a basic level of independent assessment about whether you are being asked to do something which is fraudulent or unethical. I could go on, but anyway. The Steady State, which is a group of retired intelligence analysts, has compared the trajectory in the United States to in a number of other republics that have decayed into autocracy, and expresses their moderate to high confidence that the cumulative effect of multiple reinforcing dynamics is placing the nation on a trajectory toward competitive authoritarianism. And we've seen this in a number of other countries, Turkey, Russia, India, a number of others, right? A system in which elections, courts, and other democratic institutions persist in form, but are systematically manipulated to entrench executive control, right? Theories for this, could be, that's also a fascinating topic. How much of this is just the preferences of the person who's presently the president? There's a lot of P words. Is this just a passionate Madisonian faction? So I think a lot of things are going on with something like this, and just the data that's being generated here that supports that allegation, right, of autocracy. One piece of this is, I think, a sea change in constitutional culture, kind of within the president's coalition and many people around him, away from long-standing understandings of separation of powers and the functioning of our system that we've had. I'll just briefly flag two of these, and these are important relative to this question of what courts are doing. So one of these kind of strands of con law theory that we're seeing in this administration was articulated very well by Russell Vought, who was OMB director in the first Trump administration. He is back in that role in the second Trump administration. Between the administrations, he wrote an essay in 2022 in which he advocated for what he described as radical constitutionalism. In my career, that was a term I only really heard from some of my more lefty colleagues 10 years ago, right? Like, let's re-envision the Constitution, right? Radical constitutionalism, kind of a right variant of this, right? It has the premise that we are in a post-constitutional moment because the decisions of Congresses, presidents, and the voters over 200 years have produced an unconstitutional administrative state and culture, right? And because we're in a post-constitutional moment, that just kind of liberates the executive, right? To not have to honor this stuff, right? Vought writes of a titanic struggle between the branches was envisioned by Madison and other framers, and that means that the executive can fully struggle, fully struggle against the other branches, right? Especially in this post-constitutional moment, including threats to the courts not to comply, disregarding statutes. And he urges just being willing to ignore 200 years of bad law in bad cases made by bad statesmen. Just ignore it at will. I describe this as apocalyptic constitutionalism. It adds up to the executive grabbing the lawmaking power from Congress, grabbing the interpretive function from the courts, the definition of tyranny that Madison offers. And here's the problem. Here's just the fundamental problem with this, which the framers understood so well, is that, is that the vision, right, is we have, branches of the government which can check one another to produce liberty and hopefully to produce better law, right? The result is what is unequal about them is only the executive branch has the sword, right? Congress can write words, courts can articulate words, right? Law, right? Only the executive branch has the sword, right? So if the courts completely disregarded the others, right? If they say the courts say we're in a post-constitutional moment, we're gonna go beyond our traditional judicial function, how many divisions does the Supreme Court have, right? None, right? Same thing with Congress. In the English Civil War, the legislative branch had their own armies and the king had his. We don't have that situation, right? Only the executive branch has the sword, which means that if it's a no holds barred struggle, the executive's going to win in a way that potentially extinguishes the others. And I just would say I can't see a good case from the text, structure, origins, or gloss of history of our Constitution that it envisions autocracy. I just do not find that persuasive. Anyway, so another kind of strand of this, and I'll just be even briefer with this one, is this idea that's been in circulation, I think best articulated by Kevin Roberts, the head of the Heritage Foundation, that this is the Second American Revolution. As in dramatic departure from the other regime, right? Again, this idea of just stepping beyond normal constitutional bounds. And in the interest of time, I'll just move ahead. But as I'll write up in the piece that I'm writing, I just think that there's nothing like the predicate right now for, basically a Madisonian faction. With a president with a 41% approval rating, 64% of Americans opposed to present expansion of executive power, right? That then you could have, basically just dramatic change to the constitutional system. I don't see how that works, right, in a republic, and keeps faith, right, with 200 years of lawmaking and whatnot. Anyway, okay, so I think that the constitutional theories here are a special risk when it comes to compliance with court orders. Another is secret law. This is something I've been writing about for 10 years. In short, my conclusion is that secret law, which is unpublished law, that is hard law, is a limited but meaningful exception to the general principle that the law is published. And we find it in all three branches of government. We've seen in the past couple decades, this has been used by both red and blue administration, classified OLC orders, classified directives and whatnot, have been used in surveillance and interrogation and in other contexts to go around the plainly evident meaning of the law that you could read in black and white, right? And we know that this administration, and they have publicly acknowledged that they have secret memos from the Department of Justice on, for example, which groups have been designated terrorist groups and can be targeted with lethal force. And the problem that we see here, and as a scholar of secret law, I'd love to dive into it, but I'll just put a pin in it for now, is that when the reasoning behind orders and instructions that are given out into the field, when that reasoning is classified and is secret, it creates massive difficulty for people in the field to follow their obligation not to execute an illegal order. So where are we right now? So the rule of law as it stands right now, right? So I think that together with the expansive con law theories that can be deployed, which is kind of, George W. Bush unitary executive on like a whole cabinet of steroids. That's how I describe the con law theories of this administration, right? That, legal secrecy, and then you put that together with a number of other things. So the Supreme Court in the Trump decision in 2024 essentially freed presidents to issue illegal orders. Without the risk of criminal prosecution. Yes, there's impeachment, there's 25th Amendment, but essentially freed them from criminal liability for issuing illegal orders to subordinates who cannot comply with illegal orders, right? So it puts them just immediately in a difficult position. We've seen the president concentrate legal interpretive power in himself and his immediate subordinates via a memo from the Attorney General that says that executive branch lawyers must advance any good faith claim, and then a presidential executive order that designates the president and his subordinates as the final legal authority for all executive branch personnel on the law as it's understood. Well, you put those together, and together with the Trump decision, you could have a knowingly bad faith assertion of what the law is, and the directive is, well, this is now good faith, and it has been determined to be good faith, and you must execute that. Again, it puts people in the field in an enormously difficult position. And then, of course, going back again to the Goodman study, which continues to be updated on a daily basis, just enormous risk that this administration is not going to be, not going to show the fidelity to following court orders that we've seen historically for a very, very long time. So what's my recommendation? So my recommendation, and this would apply I think in any time, but I think especially right now, which is courts need to be ready to write their opinions, both for lawyers, but also for personnel who need to know the law, people who are in the bowels of executive branch agencies or out in the field. Courts must be ready to address themselves in orders and opinions to the executive branch personnel holding the sword and who have an obligation not to execute clearly unlawful orders, right? And the courts need to especially be willing to do this where courts strike down or enjoin executive branch action, right? People in the field need to understand a court has decided, it has issued an opinion, and this is clearly what it means for you, right? This requires clear legal writing, simple legal writing, and short legal writing, right? I think those are virtues in any case for us as lawyers, right? Clear, simple, short, right? If you need to attach the 125-page reasoning opinion, fine, right? But put the bottom line up front, right? So how would this actually work? Well, I can explain this to you very briefly. I think it actually be very, very easy. For example, right, the court could write, federal personnel, they could put right in the opinion, federal personnel need to understand several things. First, in this matter, personnel may not continue this course of action, blah, 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 right? Second, it is personnel, may not continue this course of action, whatever it is. That is because the courts, under our constitutional system, are the final word on the meaning of the law, Marbury. Third, under our Constitution, there's no power for the executive branch to act that does not flow from the Constitution and is bound by the Constitution. There's no state of exception under American law, unlike other constitutional systems. There's no question that the president must comply with the law and all executive branch personnel. There's no alternative to legal compliance, and here the court is saying, whatever this matter is not legal and you may not do it. Fourth, if the executive branch seeks to challenge that decision of the court, they have the usual ways available to them. They have appeal. You can go to Congress, get Congress to change the statute. If the executive has a different view of the Constitution, they can seek a constitutional amendment, right? So in conclusion, right, so Congress can speak directly to the holders of the sword, and I think that they should do that. And I think so too, right, for the reasons that I've explained, can the courts. And I would say this at any moment in American history, but especially this moment, in view of just the evidence that I've cited of a very, very novel direction with regard to the rule of law from this administration. I think courts must be ready to do that. I don't think it'll be hard for the reasons that I mentioned. And I think it'll also pay dividends long-term in terms of norms of clearer writing, simpler legal writing, very, very direct legal writing. So I want to say thank you to all of you. I know I've gone a little bit long, and I appreciate your indulgence on a complex topic at a difficult moment. I just wanted to say thank you to all of you, for all of you as legal professionals at whatever place you are in your career, for standing up for the rule of law, to model the very best in professionalism and civic commitment, and remind you, and I don't think you need much reminding of this, but as I always do with my students in every context, and in my other writing, that is all of our jobs as a legal professional, or professional of any kind, or a citizen, to be a person of integrity and courage. Everything depends on that. Laws, ethical codes, all that stuff. It's just a pile of words, unless people are willing to be courageous and be people of integrity. And we in the law, I think, do a pretty good job of getting that message across, but I think it's an important one. So anyway, thank you.
And I'd like to thank each of our speakers, and I have a question, comment for each of them. And I'll begin with Professor Lee and artificial intelligence. Max Tegmark, who is a physicist and I'll say a public intellectual at MIT, has written on the subject of law and artificial intelligence. And he emphasizes that it may be a good thing to embrace artificial intelligence if predictability is among the cornerstones of the rule of law. Artificial intelligence may give us greater predictability. We should not want arbitrariness or capriciousness or human error. And if this is the case, why not simply embrace artificial intelligence as a means of resolving these errors in a flawed system? Professor Davidson, platforms, whether it be Twitter or now X it's called, or whether it be Facebook or what have you, platforms enjoy a good deal of legal immunity. And their algorithms, as you point out, their algorithms do indeed often serve to drive false information, false narratives, and harmful false narratives. And shouldn't we have a system there, develop a system that balances free and open discourse, but with the right of the public to accurate information and the right of individual celebrities to a proper reputation. So should we simply open up these platforms to litigation, see what the algorithms are, and provide some correctives? And Professor Rudis, so you at the conclusion of your talk, you came to a point I was going to make, and that is the professor between King James I and Sir Edward Coke back in the 17th century. That was a rough confrontation. Sir Edward Coke was sent to the Tower of London by the king as part of that confrontation. It was a confrontation, in other words, that demanded real meaningful courage. And you did allude at the end of your presentation to the significance of courage. And shouldn't we then, when we speak about the rule of law, shouldn't we then bring back a discourse about classic virtues, including the virtue of courage, the virtue of prudence, wisdom, all of these classic virtues that, as you pointed out, disappeared in the 1990s in this wave of market optimism, but for which we have a real crying need for now. Thank you. Professor Lee.
So, predictability. I want to answer this in two ways. First, let me say, as somebody who is a proud Catholic myself, I want to just address this from a sort of Catholic perspective. Are humans predictable? You know, and here I want to invoke Aristotle and L. Woods for a minute and talk about our emotional lives. Our lived experience of being human beings is not reducible to an algorithm. And I'll give you an example of what I mean by that. Right? We're all, right, nowadays fascinated by these large language models like ChatGPT, and I use Google's Gemini quite a bit. They're language models, okay? Now think about what gets lost in a language model. What do Carmelite nuns do? Silence, right? Silent prayer. Is that meaningful? Of course it is. How does a language model accommodate silence as a meaningful experience, right? This is one way that I want to address it. The second would be how I talk to my computer science friends, who would probably find that to be, I think they like to say, purple prose. I get that criticism a lot, which I'm happy to have, actually. But as informational structures, right, how much of our, just to be, again, purely scientific, we are evolved creatures with millions and millions of years worth of evolutionary history. Each moment in that history is full of accidents, right? It's random from an informational perspective. So a good deal of what it means to be a human import, for Floridi's language, is to have lots of random information contained in the way we operate. That's not predictable. It's not reducible to a code. It's not the computer science term compressible. And so if you look at the history of computer science, you find like the Turing problem. Well, there's something called the halting problem that Turing identified that says you can't make predictions beyond a certain limit. And there's some other research that says any kind of system that we build that has the ability to respond to inputs is going to probably evolve away from what we would actually do. So you have these kind of computational limits too. That would be my first blush on that. But what's the significance of that when we stop to think about the rule of law as being more than just predicting analysis? First of all, at a very practical level, at least where we are today, we have these vast systems or vast amounts of data. I think that's what's most characteristic about the 21st century is almost unlimited data and almost unlimited computational power to sort through it. And what's it find? It finds a lot of irregularity, a lot of coupled systems that are in dynamic equilibrium and things like that. But we also find a lot of bias, that a lot of human life is biased, and what happens with the programs is they tend to amplify the bias. So you can see, and this is something we talk a great deal about. I teach at an HBCU very proudly, at one of the best HBCUs too. But, and we talk a great deal about how, for example, facial recognition programs have gotten a lot better, but especially the early ones, the darker complected you were, the more likely you were to be misidentified, right? This kind of bias. And it just reflects the bias in the data, which is, after all, human data. It gets intensified. So that's a problem. The other problem, and this maybe goes to some of the other papers, but it's not... It's not as though these systems exist outside of very comprehensive commercial systems, right, that we've kind of bet our whole economy on nowadays, I'm afraid. And those financial systems have needs and put demands on the informational systems as well, right? What happened with Facebook is a great example, and I'm thinking of the 2016 election. What they found is, getting people to click on those like buttons has commercial value for them. And how do you get someone to click on those like buttons? Outrage them, make them angry. Outrage is the most powerful motivator. It's more powerful than sex, right? And people will click on those buttons to be outraged. A company called Cambridge Analytica used that very successfully to put candidates into office. It was sort of famously discussed about Brexit and the presidential election, but they represented people all the way down to county clerks, and they were very successful in doing that. That's a problem, and it's a problem that we don't get real speech when the platform is a commercial platform. There's a great book by Shoshana Noble, who wrote about her daughter's, this was a number of years ago now. Her daughter was, I think, 14 at the time, and she Googled, what is a black girl? And the response was the only way you could describe it as slave imagery. Right? Why? Because that was what people wanted. Those were the search results. Now, Google noticed that and changed their algorithm. But I think her work is so important because it highlights the bias that is inherent in this commercial system that reflects and intensifies the bias in our society, right? So we need to be really wary of that. And what we really need is students like you all from this wonderful university who can go beyond just looking at the law as a system of rules and democracy as a procedure, and remember that fundamentally, democracy is a moral practice where we come to see each other as equals. And that takes work and effort, and I think, you know, it's befitting a school like this that that's where the work can begin. Thanks.
I think one thing that's interesting about all this when it comes to both the AI LLM platforms and social media platforms is that, you know, these are private actors. So I remember for me, and I see this in my students and for just people I talk to normally, the concept that the First Amendment prevents the government from regulating your speech, but it doesn't necessarily prevent a private actor from regulating your speech. But the distinction between the power levels of a government branch in comparison to, the essentially fourth branch of these online platforms that have so much power over our day-to-day lives that it becomes such almost a more impactful regulation of speech than if the government did pass a law or take an action that regulates your speech. And, you know, the issue here is both the power of regulation in our day-to-day lives, but also power in policy. Because when it comes to whether Congress will take any action to, increase the potential liability on this front, tech companies are one of the biggest, powers as far as influencing policy because they have the money to do so. I primarily, work in the music industry, and when the Music Modernization Act passed, to update copyright law for the streaming era, the only reason why that was able to pass is because all the tech companies were on board. If it was just, the music industry companies, they wouldn't have enough influence over Congress to be able to make that happen. So I would encourage people who are interested in, contract law or commercial law to really think about how that does interact with the same rights and things that we have that we look at under constitutional law, because, that's really another source of law. You have, your legislative branch, executive branch, judicial branch, but you also have private contracts, and every time you access a social media platform, you're agreeing to their terms. Essentially what they would say is you agreed to this, using this. So whether or not there is going to be regulation of that, right, having some kind of, on the flip side, pushback from the private sector on that, I think is really what's going to happen, because at the end of the day, a private business is motivated by profit, and that's their primary liability is to their shareholders.
Thanks so much. So on virtues, you mentioned, I think you used the term classic virtues. Very much endorse that and agree what you said. Agree with what you said on that. So you mentioned courage and wisdom. I could add some other terms to that. But what that speaks to is what the founders understood as civic virtue, sometimes called civic republican virtue, which you may have encountered in your reading and your studies. But this was enormously important to the founders. George Washington, in particular, wrote a good deal about this. It's all over his writings. It's all over his conduct. And it was informed by Washington's sense of his own weakness. The biographies of him that you'll find, other accounts, where this is an individual who is in a constant state of controlling himself, because he had a sense of his own urges, his anger, his passion, his, when he felt slighted, to be vindictive, right, to be selfish and not think about the general public interest and the project. And he was constantly battling with himself. And he had the view that a lot of people did then, and it's a long intellectual tradition, right, that we have various potential directions that we can go in, right? We can go in a virtuous direction, we can succumb to wickedness, right? And it requires enormous self-control. And you look at the constitutional architecture that was built, and as Madison writes about, and Hamilton and others, so much of this was predicated on the idea that, as they wrote, men are not angels. And you leave people to their own devices, you give them power, you give them the sword, and some number of them are going to succumb to wickedness and oppress other people, right? Passionate factions. Federalist number 10, right? A minority faction, even a majority faction, right? If it gets unlimited power, is going to oppress other members of the polity. And so what you want is design some sort of architecture, right, which restrains individuals, restrains factions, whatever, but the virtues, right, that are going to be part of that, right, is a sense of courage and wisdom and also prudence, enormously important to them, to the framers. As my colleague at Ohio State Moritz College of Law, Ned Foley, said in a really terrific speech earlier, or talk earlier this week, he noted how World War II essentially refueled that civic virtue for the United States. Here you had this conflict, right, against the worst authoritarian regimes in history, and you had, conscription, right, and, on the home front, a common effort, right, a common lived experience for this entire greatest generation, and they uploaded a sense through that, right, of like the effort and struggle and self-restraint that is necessary to sustain democracy against its alternative, right? They saw it. And that generation had then, even though they were in Team Red and the Team Blue, this really, really common set of commitments, right, which kept American politics very well within the 40-yard lines. I certainly saw this when I worked for the U.S. Senate in the 1990s and the 2000s. There was this cadre of World War II vets on both sides of the aisles, and they would disagree on tax policy and, whatever, right? But they knew each other. Many of them were personal friends. Think of Ted Stevens and Dan Inouye. And they just had like a common sense of values and what is acceptable in governance and what is expected of people and what is not. Certainly the greatest generation had, was not perfect. No generation is. But that was a powerful force. Well, what happened is they aged out. Right? From Congress, from executive boardrooms, civic associations, everywhere, right? They leave the scene, right, by the mid-2000s. And what happened right about then in the 2010s, right, what I would describe as, and I saw it up close, was the mainstreaming of what for like the first 2 or 3 decades of my life we would just call crazy, right? It just got mainstreamed and just wild claims. And, I'll be honest, like this radical constitutionalism stuff, just like unrestrained assertions of power, right? That like, that's okay and that's going to work out, right? I mean, so much of what we see, and it's not, it's not completely a red-blue thing by any means, I think has reflected the absence of that generation. I think the result of that has just been just utterly cratered standards. I think of what were controversies that ended political careers even 15 years ago, to go back before that, those things are just like, there are like 50 of them a day, right? What it reflects to me is just my view is, I think a just colossal collapse in standards in our country of personal conduct, in terms of how we treat one another within our common political community and social communities. And so we wonder, well, what's going to sustain that? What's, these classic virtues of courage and wisdom or prudence? President George H.W. Bush, he was mocked for it, but I remember it. He plainly felt the most important virtue we could have is prudence and care, right? What's going to, inject some of that? Well, I think part of it is professionalism. Again, professional values. In whatever profession you're in, as I've written about, there are kind of a common core of ethical commitments in every profession. And one of them is, they include, civility, fidelity to the truth, willing to listen to others, engage in reasoned debate and conversation. So I think there's a special role for the professions right now, and especially for us because of our civic role. I think it is, without any question, question challenged by where, both of you were talking about this technological moment we're at. I think just massively challenged by it. Our brains were not designed for the level of reinforcement and habituation to crazy and horror that is your experience as soon as you hop on a social media platform, right? Our brains are not built for that. And that stuff, I think, is just, it's psychologically overwhelming the instincts that we might have towards, again, these more classic virtues, which I think have both civic versions and then kind of religious ones as well, right? But anyway, so I couldn't agree more. So it's I think those classic virtues are very cool, and I think if we have a better future ahead, I think it lies in those things.
Schedule, I think we have to just the question and answer session. Yeah. I don't think so because we're all pretty fast. Yeah.
Planning. Well, first, let's thank our panelists here for a wonderful presentation. So to stick on time to our next panel, we will take a 10-minute break, and we'll ensure that we will save questions for the second panel, and we'll take a 10-minute break and return at 10:30. So thank you.
Good morning, everyone. Thank you for being here today. It is my pleasure to introduce our speakers who will be discussing a topic that is fundamental to any just and functioning society, the rule of law. Our first speaker is Henry Frank Carey. Henry Frank Carey is Associate Professor of Political Science at Georgia State University. He has been since 1998. He has published many books and articles on international law, human rights, and comparative democratization. He received his PhD from Columbia University in 1997. His most recent books are Understanding International Law Through Moot Courts, Genocide, Torture, Habeas Corpus, Chemical Weapons, and the Responsibility to Protect. He also wrote European Institutions, Democratization, and Human Rights Protection in the European Periphery, Trials and Tribulations of International Prosecution, as well as Privatizing the Democratic Peace Policy Dilemmas of NGO Peacebuilding, and lastly, Reaping What You Sow, a comparative examination of torture reform in the United States, France, Argentina, and Israel. Our second speaker today, we have Kimberly Breedon. Kimberly is a professor of law at Ohio Northern University Pettit College of Law, where she teaches will and estates, constitutional law, civil procedure, and legislation and statutory interpretation. She previously taught at Barry University, the University of Cincinnati, and Atlanta's John Marshall Law School, and was a visiting legal researcher at Columbia Law School. She also earned her JD with Order of Coif honors from the University of Cincinnati and her LLM with highest honors from Columbia Law School. Our third speaker today, we have Dr. Courage Malambo. Dr. Malambo is a Zimbabwean scholar based in South Africa, Walter Sisulu University. He was a visiting scholar at the Wilson Center for International Scholars from December 2024 till July 2025 in the USA. He's authoring a book on China-Africa economic and political relations. He has worked with US-based international organizations like the International Republic Institute of USA on democracy, authoritarianism, and Chinese economic expansionism in Africa. Dr. Malambo has authored articles on China-Africa relations as well as on politics, women's rights, women's health, social justice, and economics. And lastly, we have Enrique Guerra Pujol. Professor Guerra Pujol earned his JD from Yale Law School after graduating with the highest honors from the University of California, Santa Barbara. Following several years in business law practice, he began his academic career in the Pontifical Catholic University of Puerto Rico and now teaches at the University of Central Florida. His research focuses on markets, property rights, and the philosophy of law. And his scholarship includes numerous articles and book chapters such as Godel, Loophole, Evasion, model of litigation, and the poker litigation game. Thank you. Let's welcome our speakers today.
Should I start?
Yeah, Professor Carey, please go ahead and start.
Thanks everybody. It's an honor to be back at the university, discuss this important topic, the rule of law. I'm Chip Carey. My parents gave me a real name, Henry, in case there's any confusion about that, as well as my nickname. I am named Henry after my father's older brother, who was killed in combat in World War II, and he died not in vain. And I fear greatly that the situation imperils that legacy. I'm going to talk about sultanistic democracy. It's a stretched concept, as it were, because the original concept of sultanism was developed by Max Weber, the German political sociologist in the early 20th century. And I'll tell you why I picked this concept to focus on in the context of democracy as opposed to the context of authoritarian rule, which Weber had developed. Max Weber said that sultanism operates primarily on the basis of discretion. Sultanism is an ideal form, an ideal type that Max Weber developed, and ideal types are pure forms. Very rarely in reality are ideal types the exact form it takes in practice. And in this particular case, sultanism, many of the sultans that have been described, especially by Stepan and Linz, as ideal types, even they didn't last forever. So in that sense, I think it's okay to introduce the idea of sultanistic tendencies in democracy, sultanism as an adjective as opposed to as a noun. Sultans should be distinguished from sultanism. Weber has been criticized for the Orientalist use of this term sultan from the Ottoman Empire and from many other Muslim kingdoms and non-kingdoms. And the lifestyles were lavish and decadent. Over time, they increased their power, and the regimes became very, very personalized. And the idea that there was any ideology or any rules de facto in these regimes were not present. And in effect, you could say if authoritarianism in the rule of law dimension is distinguished from democracy as rule by law, as opposed to rule of law, where law is the pretext, in sultanism, there's no such sincere, authentic attempt to even come up with a pretext, at least in the ideal type. When we look at this ideal type of sultanism, it's in the context of legitimacy that Weber developed sultanism as opposed to the three main forms of legitimacy: traditional legitimacy, charismatic legitimacy, or bureaucratic legal authority. We think of democracies in that third category, but it's important to emphasize that Max Weber thought that legitimacy is a form of domination, that in fact, even in bureaucratic, rational, legal legitimation, the state has to dominate over society. And this is echoed in Federalist 51, where the Federalists wrote, in effect, that at first the state has to conquer the society before the society can conquer the state and control it through what was then called a republic, res publica, rule of the people, as opposed to demokratia, the demos in Greek form of that word, democracy, the people, and kratia is the rule. So you have many different conceptualizations in practice of what rule by the people means. The Republican ideal tends to emphasize the republic, that is, the rule of law, and the democracy form of it, the Greek form, tends to emphasize the electoral dimension. But it's important to emphasize that both elections and the rule of law, if you're going to use this narrow definition of democracy that was developed, let's say by Guillermo O'Donnell, as opposed to Robert Dahl's conceptualization that only focused on elections, both of them require the rule of law to function properly. So in a sense, you've got the rule of law as a distinct autonomous area, which Stepan and Linz focused on constitutional adherence, as opposed to elections, which require the playing by the rules that are legally binding with the penalties of law established, but still is mostly focused on the selection of leaders. To put it differently, the electoral dimension focuses on who's going to govern, and the Republican legalistic dimension focuses on how you govern. Do you govern according to the law or not? Sultanism, in Weber's sense, was an authoritarian form of government characterized by extreme personalism and the presence of the ruler in all elements of governance. Because of this personalism, rules may exist on paper, but they can be ignored in practice. The ruler may or may not be present in economic or social life, and thus there may be some pluralism in these other areas, according to Stepan and Linz, but this is never true of political power. Political power under sultanism has the personal presence of the ruler in every single decision. Can the concept of sultanism be stretched to democracy? I'm arguing that it can, and it's helpful because we have, in most cases in the world today, hybrid regimes. The United States is no longer a liberal democracy. It's some kind of authoritarian democracy or sultanistic democracy. Even under Trump 1, which I'm going to spend most of my time talking about for two reasons, sultanistic democracy was probably the best character description in my argument of Trump 1, Trump 45 in his first term. But even though sultanism is more common under authoritarian and autocratic rule, as a hybrid regime, when leaders personalize decision-making and instead of following established institutional or legal processes, and to whatever extent that happens, it's departing from the ideal type of liberal democracy or pure democracy, however you want to call it. There are other concepts that are similar to sultanism. Personalism and patrimonialism are two of them. And Weber's definition, according to one translation from the German, is that sultanism is an extreme form of patrimonialism where the personal element intervenes much more than just patrimonial regimes that are run by a party, that are run by the military, rely more systematically, let's say, on coercion. But generally, coercion is too costly. And most regimes, including authoritarian regimes, even very brutal ones that are not sultanistic, run typically by the military or a civilian with the military as the right-hand man, as it were. It's very expensive in terms of support for the regime, and there's a risk to the regime's survival if coercion is used too much. And just as corruption is characteristic of all types of regime, including liberal democracy, in practice, the rule of law would forbid it, probably in most authoritarian regimes. And so the Sultan will, to the extent necessary, rule by law if he needs to come up or she needs to come up with a rationalization for corrupt rule. In Stepan and Linz's work in 1996 and others in Linz's earlier work on pure sultanistic regimes, there was a path from democracy to democracy from sultanism, though it was much more perilous path than the transitions from authoritarian rule, such as bureaucratic authoritarianism, such as in Argentina, or single party rule. Those had more established institutions, including legal institutions, both in the courts, narrowly speaking, but also the practice of following the rule of law in the executive branch, and for that matter, for the courts themselves. Stepan and Linz argued about 5 spheres of influence in these transitions to democracy: political and civil society are the first two, a functioning state, market society, and the rule of law. The rule of law in their conceptualization was adherence to the Constitution, and in sultanism, it's the least developed. But when we're talking about sultanistic democracy, we do have more robust spheres, especially political society. And what we see now in both Trump administrations with extreme personalism is that the Republican Party has not stood up to him when there is good, clear law. And nor has the Supreme Court, frankly. We don't understand the Supreme Court in conceptual, theoretical terms. We don't know whether the theory of the unitary executive is a fully developed theory and that it's consistent with jurisprudential methods, or whether this is an ideology of personalism, or it's intimidation, or it's corruption. But we do know that judges, face much more personal, severe threats, including the Supreme Court itself, with people protesting at their houses and so forth. That's a form of intimidation as well, and that we won't know, in perhaps for decades, what is motivating this court not to check good law and to merely permit going forward, in at least in temporary restraining orders, something like 20 out of 24 court decisions. The target keeps moving, and I don't have the latest statistics. I'm going to focus primarily on the US, but I'm going to talk about other countries as well in my limited time. But it should be pointed out that even tradition or even charisma doesn't quite capture sultanism, because in Weber's conception of charisma, there is something quasi-religious about the charm that people defer to the ruler. But we can say in President Trump's case, at least to the extent that the MAGA element is inspired by Christian nationalism, or whatever term seems most appropriate, sent by God with all his imperfections to save us from this current calamity, as some people articulate. We don't know to what extent this kind of commentary is representative of even the MAGA base, let alone those who still approve of Trump's rule. So the ideal authoritarian sultans were the two Duvaliers, Francois and Jean-Claude Duvalier in Haiti, Trujillo in the Dominican Republic, Bokassa in the Central African Republic, Kim Il-sung in North Korea, Ceausescu in Romania. And then we have, mixed types like Pinochet, where he was personally involved in many key decision-making moments in Chile, especially after he consolidated power after the first few years of the coup of 1973, the other 9/11, as it were. But Pinochet, his rule was not as long as these other ideal type examples. Chile was the strongest functioning democracy in South America, a rival of Costa Rica for most democratic of the Latin American countries that survived the long periods of military, and in the case of Mexico, civilian dictatorship. But when he held the plebiscite, he looked to a legal form to continue in power under a new constitution. He lost the plebiscite in 1988 and left power voluntarily in 1989. Sultanistic democracy sounds like an oxymoron. Sultanism is not consistent with democracy, but we talk about the extreme patrimonialism. We look at in Trump too, the enormous amounts of money he's making from cryptocurrency, the clear benefits to his family business that would be normally impossible to tolerate in a liberal democracy as just early indicators. We can say that around the world, South Korea had an episode recently of sultanistic democracy with General Park's daughter, Park Geun-hye, I can't pronounce the Korean, I apologize, was impeached in December 9th, 1987 for corrupt activities, many connected to a close family advisor. That advisor was kind of like a shaman, daughter of another Rasputin-type figure in that particular episode of sultanistic democracy. And Daniel Ortega in Nicaragua now has consolidated sultanistic authoritarianism, but he came to power from democracy. He packed his Supreme Court to ratify and rubber stamp all his decisions, especially beginning with the third consecutive term against the Constitution. And his wife is the vice president, which is, the tendency of most of these regimes to have family members involved. John F. Kennedy wasn't a sultanistic democracy, and he wasn't in power very long. But Robert Kennedy, his brother, was the Attorney General. Other precedents that we've seen in the past include the fact that Congress reacted to this in 1967 by having an anti-nepotism statute, nicknamed the Bobby Kennedy Law, to make sure close relatives no longer assumed official positions. But Jared Kushner and Ivanka, his wife, had official positions without being confirmed by the Senate because they were part of the presidential White House staff. So it's a legal distinction without a practical difference that the nepotism law was not enforced. And Hillary Clinton, for that matter, led the campaign, the unsuccessful campaign under Bill Clinton's administration to implement healthcare reform. She was unpaid on this issue, and after it failed, she removed herself from active participation, possibly because they saw it as a liability under the Clinton administration. And George W. Bush, two of his most formidable foreign policy advisors, Donald Rumsfeld and Dick Cheney, were alumni of the George Herbert Walker Bush administration. That's quite a difference, and it's not necessarily an indication of loyalty, but after 9/11, both of them approved arbitrary policies that went against a very good law. This was pointed out by an earlier speaker, permitting torture and coming up with an Orwellian name, enhanced interrogation. Warrantless surveillance was also legalized, and targeted assassinations, the drone campaign, but also bigger missiles, was begun under George W. Bush's administration, and then President Obama expanded it in what was largely a murderous campaign that's being imitated now in the Trump administration against alleged drug traffickers. And many innocent people were killed by the Obama administration. The unitary executive facilitates sultanism because it allows the president to monopolize executive power until he's reversed by the courts. And these 20-odd cases where a temporary restraining order was not authorized in just these 11 months of power, it's basically putting the president above the law. What makes Trump different in looking at the United States example is that someone like Trump coming in from the cold brings his family and close associates into power. In the first administration, sultanism was not consolidated, in large part because members that he hired in the cabinet stood up to him and said no, and he steadily removed them. It's interesting to note that the arrival of Jared and Ivanka Trump was followed by a much greater power given to them because they were, at least in those days, were personally loyal to him. His daughter has not come back in the second administration, but Jared played a major role in the Gaza peace plan, and he obviously benefited enormously from this sultanistic patrimonial element, where his hedge funds received billions of dollars of investments from people that he went and see. Actually, on January 6th, the very day the Capitol riot, he was overseas collecting money for his hedge fund on company time, as it were. So people were removed, including people who had disobeyed the law in the first Trump administration. Michael Flynn, after lying about his meetings with the Russian ambassador to the U.S., U.S. Deputy K.T. McFarland was cashiered and became U.S. Ambassador to Singapore, and replaced by McMaster, who stood up to him and was removed. Steve Bannon was removed as well because he wasn't as personally loyal as Trump wanted, and he represented a different wing within the MAGA movement, the more nationalistic MAGA from below, as it were, and not MAGA from above with the various super rich people involved. So instead of a team of rivals under the rule of law, the Trump presidency and Trump too especially were picked in terms of their personal loyalty. You see people like the FBI director shouting and screaming in a congressional hearing. I think it's unprecedented. I'm not certain, but I don't think we've never ever seen someone scream and shout for minutes at a time at the same time as congresspersons are asking questions of Kash Patel. And that's the extent to which personal loyalty allows this kind of strange behavior. We can say in the first Trump administration, at least two key figures saved democracy, or at least there's some evidence that they did prevent an authoritarian coup. Mike Pence, the vice president, in refusing Trump's order to take this fake slates of electors, which the White House currently maintains were not fake and were just contingency, but there's certainly lots of evidence to suggest the contrary. And then Mark Milley, who, at least according to the account of Bob Woodward in his book, to some extent disobeyed. It's not clear if it was a direct order or not, but an order to invade Iran between the election on January 6th to wag the dog, as it were, something that Bill Clinton was accused of in his attack on Haiti and his attack in Bosnia against the Serb forces. In any event, Mark Milley apparently said, "No, I'm going to disobey this order, not because it was necessarily illegal, although you could make that case in terms of war powers, but in any event, on the grounds that there was no reason that was motivating it other than that Trump wanted to stay in power." In any event, that's a hypothesis. When we look at other cases around the world, we can say that there have been long runs, especially Erdogan in Turkey and Orban in Hungary. Orban will face an electoral test later next year, and it's not clear he's going to win the elections if it's an honest election. Obviously, the structural forms in which Erdogan was reelected this past year allows him, with press censorship, arrest of journalists, something that goes on in Turkey and not yet in the United States, although civil lawsuits against press forces suggest a lot of intimidation and a lot of compromise of the independence of the free press. But we saw that, Duterte was forced to leave power in the Philippines. The Polish government lost an election and left power. I already mentioned the Park case from 2017. And Trump was prevented from consolidating authoritarianism in a coup on January 6th by both Mike Pence and a few weeks or before that, perhaps by Mark Milley. We've got a bunch of uncertain cases ongoing, including Bongbong Marcos in the Philippines, who sent Duterte to the Hague, to the International Criminal Court, for his summary executions of alleged drug traffickers. And we don't know whether Bongbong Marcos will imitate the purest form of sultanism that existed from original elected path to sultanistic authoritarianism of his father, Ferdinand Marcos, a regime also characterized by family members, especially his wife, having enormous power. And the current case of Slovakia, which has had a right-wing government, but it's not personalized, even though it's highly patrimonial. I don't know how my 15 minutes are up, but I think I'm probably out of time. There's a lot more that I can say. This is just to conclude. I will say that I'm much more of a comparativist, and I know a great deal more about the other cases than I've talked about today, but I didn't want to talk too much about Trump 2, the Trump 47, because others have mentioned it, and because it's much more of a moving target, and we'll have a much greater sense of whether sultanism, democracy, can remain a hybrid form with democracy, the noun, and extreme personalism and corruption, and considering the state to be the personal patrimony, the personal wealth of the ruler, and the arbitrariness of decision-making will consolidate authoritarian rule, and then we'll have some kind of sultanistic authoritarianism in the remainder of Trump 2 or not. A lot will depend on the court and the deference to the court by the Trump administration. If the court chooses to be much more forceful when they rule on the merits on these issues. Thank you very much.
Professor Breeden. Good morning. Good morning.
Good morning.
Your fifth JLPP symposium. Thank you for participating.
Well, always an honor, always a pleasure. I really appreciate the opportunity to join you. I wish I could be there in person. I wish I could be participating.
Missed a nice dinner last night.
I know, I'm sure I did, and great company as well. I also want to apologize. I have to scoot in and out because I have teaching duties today. So I was unable to join you for the morning sessions, and I'll be back for some of the afternoon sessions, but not for all of them. The title of my presentation today is Cui Bono, Corruption, Presidential Immunity, and the Rule of International Law. So, cui bono, who benefits? This is a question that the international law community must ask after the past several months of a nearly constant onslaught of policies, practices, and positions taken by the current U.S. administration that have undermined, eroded, and in many cases violated international law. Since returning to office for his second term, Trump has, among other things, undermined the principle of sovereignty, weakened international anti-corruption commitments, disengaged from the United Nations Human Rights Council, conducted military strikes in international waters, resulting in extrajudicial killings, actually for the purpose of extrajudicial killings, undertaken erratic trade and tariff policies, withdrawn from the Paris Climate Agreement, and abducted, detained, and deported foreign nationals without due process. This is a brief, illustrative list. It is by no means exhaustive. But I want to point out that during this period, and also including the several months during the lead up to the 2024 election, Donald Trump also engaged in a string of increasingly blatant acts of corruption, that is, abusing his public office for his own private gain or promising to abuse his public office for his own private gain. So he has received money donated to his inaugural fund, money donated to fund construction of the White House ballroom, money donated to his presidential campaign, all in exchange for various policy positions and decisions that benefit his donors. In addition, among other things, there have been crypto investments made to the Trump-owned managed investment accounts in exchange for crypto-friendly policies, and at least in one instance, presidential pardon for criminal conduct for one of his donors. Now, some of these acts may run afoul of domestic criminal law. Some of them may constitute civil violations, and some may fall into a category of legal corruption, that is, conduct that is not prohibited by law, but that the public nevertheless understands broadly as corrupt conduct. So the aim of my current project is to track the connections between U.S. policies and corrupt practices, as well as violations of domestic and international law, and to show how the U.S. domestic legal framework, particularly the U.S. Supreme Court's recent presidential immunity decision, enables that corruption and permits a president to commit criminal acts with impunity, which in turn facilitate violations of international law. All right, so first, the Supreme Court opinion. Now, I came into the tail end of the morning session, so I think you probably have already gotten some of this background information. I'll keep it brief. By way of background, first of all, U.S. campaign finance law and an unregulated inaugural committee donation structure had already provided fertile ground for a president to obtain private gain in exchange for adopting policies favorable to his political donors. In 2024, the Supreme Court ushered in a new doctrine that effectively shields the chief executive from domestic prosecution for any criminal action he undertakes, pursuant to the exercise of his constitutional authority, including criminal conduct from which the president may personally benefit. This watershed case, Trump versus United States, sets forth a tripartite analysis for determining whether a former president can be criminally prosecuted for actions taken while in office. First, according to the court, a former president is absolutely immune for any crimes he may commit while exercising his core constitutional powers. That is powers that are committed exclusively to the president by the Constitution. Second, he is presumptively immune for any criminal actions he has taken while exercising constitutional powers shared with Congress. And finally, a former president enjoys no immunity for any crimes he has committed while engaged in conduct outside of his constitutional power. In addition, no evidence involving a president's constitutionally authorized conduct may be used in a criminal prosecution against him for actions that are not protected by presidential immunity. Although legal commentators have pointed out the framework's lack of clarity, and although they debate its contours, the incumbent chief executive has proceeded as if he is entirely unconstrained by any law. The lawlessness in this regard is evident in many areas of policy and practice. I had drafted this paper to point out three particular areas: trade and tariff policies and practices, climate and energy policies and practices, and mass migrant detention policies and practices. Given the time constraints of the presentation, I will delve into the details for only one of these, and that one is the trade and tariff practices. So to say that Trump's tariff policies let me back up. To say that his tariff practice, his policy, has been erratic would be an understatement. So over the past several months, he has imposed, modified, paused, rescinded, and reimposed tariffs numerous times on all U.S. trading partners. Just by way of example, shortly after returning to office for his second term, he signed an executive order imposing 25% tariffs on products imported from Mexico and Canada and a 10% tariff on China. As the purported basis for the imposition of these tariffs, he declared a national security threat from illegal migration and the importation of drugs into the United States. Shortly thereafter, on April the 2nd, of this year, Trump announced a new round of tariffs to become effective on April the 5th. And that new round of tariffs would include a minimum 10% tariff on goods from all U.S. trading partners and a more draconian country-specific tariff reaching as high as 50% on approximately 60 countries. Only a few days later, on April the 9th, he announced a 90-day delay for the implementation of the higher tariffs for most countries, but keeping in place the 10% minimum. China proved an exception, and on the same day he announced a pause in the effective date of the tariffs imposed on other countries. He raised tariffs to 145% on goods imported to the U.S. from China, only to backtrack 2 days later by announcing that consumer electronics would enjoy at least temporary exemption from tariffs on goods imported from China. In May, the U.S. and China announced a 90-day period of mutual tariff rollbacks, with Trump reducing tariffs on Chinese imported goods from 145% to 30%. Now, each announcement prompted a direct and immediate impact on stock prices. The stock market went down whenever tariffs were imposed, and the stock market went up when there were freezes or lifting of tariffs. And in at least one notable case, Trump announced by way of a social media post that it was, quote, a great time to buy stocks only a few hours before lifting tariffs. In addition, Trump Media and Technology Group announced the launch of a managed investment account, part of the Trump-owned businesses. And so Trump's ability to increase or decrease the price of nearly any publicly traded stock by imposing or lifting tariffs will allow him and others with advanced knowledge to time their trades accordingly. And Trump can now also influence the performance of his own company's managed investment accounts from which he profits through his tariff policies. So these actions and Trump's financial stakes in them have raised questions about whether he has violated U.S. insider trading prohibitions. Insider trading for public officials involves buying or selling securities based on material, non-public information obtained through their official duties. Information is non-public if it is not widely disseminated through official channels, including internal documents or confidential discussions. Material information is any data that could reasonably affect a security's value or an investor's decision, such as details about upcoming legislation, regulatory decisions, or economic policies not yet announced. Public officials often will gain access to sensitive information before it becomes public. And trading on any foreknowledge or tipping off others who then trade on this knowledge will constitute illegal insider trading. This conduct is deemed a breach of the duty of trust owed to the public because it exploits information gained through public service for private financial benefit. However, even if a prosecutor could prove the elements of insider trading beyond a reasonable doubt, and apparently insider trading is a notoriously difficult offense to prosecute, Trump could claim that his comments and his conduct fall within his constitutional power as chief executive, and that therefore he is immune from any insider trading violations. Trump's tariff policies also likely run afoul of U.S. obligations under the General Agreement on Tariffs and Trade, the GATT, which requires World Trade Organization member states to implement non-discriminatory trade policies, which imposes a duty to comply with agreed caps on tariffs and which establishes specific channels for dispute resolution. The failure to follow the required channels violates GATT Article 2 unless a recognized exception applies. For the imposition of U.S. tariffs under the Trump administration, Trump has claimed a national security interest, again, purportedly based on illegal drug importation and irregular migration. However, under World Trade Organization jurisprudence, the requirements for the exception do not seem to be met. Article 21 of GATT provides in relevant part, nothing in this agreement shall be construed to prevent any contracting party from taking any action which it considers necessary for the protection of its essential security interests, taken in time of emergency in international relations. In addition, the World Trade Organization panel has set forth a three-pronged test for determining the validity of a claimed security-based exception. First, regarding the phrase emergency in international relations, the WTO panel has stated that the existence or not of such an objective, the existence or not of a national security emergency is an objective determination. To qualify as an emergency in international relations, the state of affairs between states or other participants in international relations must be at or near a breakdown and must be bordering on war or armed conflict. Accordingly, an emergency based wholly on economic factors does not constitute a security-based exception unless the economic emergency is either a cause or a consequence of a breakdown or near breakdown in relations between states. Second, the adopted trade measure must have a plausible connection to the security interest being claimed as justification for the exception. And finally, the claimed security interest may not be used as a means for disguising purely economic protectionist measure. And the tariffs that I just described, imposed by the United States during the early weeks and months of Trump's second term in office, as well as subsequently imposed tariffs, do not meet the requirements for the national security exception and therefore violate U.S. obligations under GATT. First, international relations with none of the U.S. trading partners have reached a breakdown or near breakdown approximating armed conflict as a result of illegal migration or illicit drug importation into the United States. So no essential security interests are threatened, and accordingly, no plausible connection exists between such security interests and the tariffs imposed. It would seem that these measures appear to be nothing more than instances of economic protectionism. I forgot to set my timer, so I'm not exactly sure how much time I have left, but I did promise that I would stick to just this one example. And so based on this example, I think it's fair to say that the Trump, or I should say the presidential immunity doctrine, newly adopted by the United States Supreme Court, has emboldened the incumbent president. The domestic U.S. legal framework does not generally include a private right of action for violations of international law, unless those private rights of action also run afoul of U.S. constitutional or statutory law. And the U.S. Supreme Court, as currently constituted, seems to place little to no value on international law as a legal source for interpreting the obligations of the U.S. government, at least in many instances. So a president who is indifferent to U.S. obligations under international agreements and who cares nothing for either the best interests of the nation he is supposed to serve, nor for the nation's loss of reputation and influence in the global community, has little reason to comply with the mandates of international law on their own terms or within the framework of accountability under international law. Now that the U.S. Supreme Court has effectively placed most of a president's corrupt conduct beyond the reach of domestic criminal prosecution, the only impediment now standing between such a president and the pursuit of private gain in the exercise of the president's core constitutional authority is political accountability. If criminal conduct is not forbidden to the president, then why should anything less be so? If a president is personally immune for domestic criminal law infractions, why should the president avoid violating international legal obligations, which, with a handful of exceptions, impose no penalty on an individual head of state? So where does that leave us? Well, the truth is, I'm not sure. I do think one of the really important mechanisms for accountability going forward will reside in the people. But political accountability will depend on journalists and legislative investigations to follow the money, to find out who benefits, and to ensure that the public understands when decisions are being made in ways that potentially violate international legal norms and requirements, potentially violate domestic law, even if a president himself cannot be held accountable. And it will be important for those institutions to call out the abuses and linkages to corruption. And with that, I will end, and I look forward to your comments and suggestions and questions. Thank you.
Thank you. And next we should have Courage Malambo.
Okay, thank you. Thank you. I'm delighted to be part of this symposium. And my presentation reflects work that is still in progress. And I'm currently developing a book on China-Africa political relations. And I'm going to be presenting on the authoritarian superpowers and the erosion of the rule of law in developing countries. And I'll be looking at the case of China in Africa. And so here we have a rule-based international order. And this rule-based international order sought to guide African states towards a trajectory that is based on democratic institutional accountability and also the rule of law. So international states, especially liberal democracies, have been giving Africa diplomatic engagements. Okay, so we're saying that international states, liberal countries have been giving Africa assistance right? They've been giving development assistance in government reforms, thinking that African nations would gradually converge towards institutions that uphold constitutionalism and also the rule of law. And under the rule of law, well, we expect the exercise of public power to be conferred by the law, and we expect everyone to act in accordance of the Constitution. And also, we expect the courts to be impartial and independent. And this is vital for creating and maintaining democracy and also for protecting human rights. And it is also important for economic development. And in many African states, we're expecting 6 elements of the rule of law to be implemented. And these include the principle of legality, legal certainty, prohibition of the arbitrary exercise of executive powers, the separation of powers, and also we expect everyone to be equal before the law. However, this has been disrupted by the rise of authoritarian regimes, particularly China and also Russia, right? Because we've seen that China's governance model emphasizes state sovereignty and also non-interference over democratic norms. And this has offered African political elites avenue to access resources and legitimacy without adhering to the rule of law. We see that now many African nations are shying away from Western nations because they feel that China is there to defend them when they are not adhering to the rule of law. So this has become a problem. Instead of converging towards the rule-based international order, many African states now are diverging. So as a result of this, some states, as I said, are drifting away, right? And to see that many governments are increasingly disregarding legal constraints. And this is also weakening the rule of law mechanisms because the masses cannot hold them accountable. They are doing as they please. But now we need to pinpoint the problems or the challenges that contributed to this happening. And from my book, I've managed to identify 2 factors. Right, the first one is geopolitics. Right, so we have seen that China is trying to position itself as a global leader. Right, it wants to replace the United States as a global leader, and is trying to attract developing countries. Right, so it's using its infrastructural development programs and also giving loans to African countries so that it can charm them. Right. But however, this is offered, an alternative, to these African states, because they no longer rely on traditional funders such as the World Bank and IMF, which usually give support, which used to give them support and would also place conditions whenever they were giving them support. They would ask them to promote democracy, respect the rule of law, and have free and fair elections. Then the second factor is that there seems to be a disconnect between African governments and the citizens who elect them. Right. So this disconnect has made African leaders not to uphold the social contract, and they do not even prioritize the will of the masses. This is so we now have a government which is governed by a political elite, and also have the general populace, which is not prioritized by the African governments. So the emergence of these 2 distinct entities in Africa, which is the political elite and the masses, it led to a situation where citizens are pushed to the periphery of governance. And the political elite also, try by all means to stay in power, and they're much more worried about closing the political space And as a result, important elements, government elements such as the rule of law, are violated. However, despite these problems, we see that China continues to engage with such states and still supports them despite their disregard for the rule of law. Because with China, it's not really interested with governance issues, not really interested with democratic issues. What it seeks to do is siphon resources in Africa and also try to attract numbers so that it can also lead international platforms such as the UN. And in the future, it is likely to become a leader in the global arena. So we do have some cases where China has been disregarding the rule of law. For example, we have the issues in Zimbabwe where China is extracting resources in a way that is not developmental. So the Zimbabwean masses are suffering. You would see that in many cases, China is displacing the Zimbabwean citizens. And if they try to approach the courts, they lose many court cases because most of the judges in these courts are appointed by the ruling party ZANU-PF. So they do not adhere to the constitution or the legal, or the regulations. They just have to listen to the political elite, which is controlled by the Chinese government. And we also have the issues that were happening in Zambia. They are also doing the same. We've heard of pollution there. The Chinese do not follow the environmental laws there. And then lastly, we also have the case of Tanzania, whereby China is having what is known as an ideological school for countries, for liberation movements in Southern Africa. So they are teaching them how to govern. And even judges are also asked to attend the ideological school. And it is not part of the institutions that support constitutional democracy. It is just an authoritarian ideological school that has been set aside by China and the political elite in Africa. And for that note, I end my presentation. Thank you.
I want to apologize. The original, by the way, I know I'm in the enviable position of now standing between you and lunch, as is this speaker in my slot always gets to say. And so, but I have designed this to keep this short. I do want to do a little bit of justification. When I originally saw the call for papers, I will tell you, I'm a little bit more skeptical about all these alarm bells ringing now about rule of law. If we were concerned about rule of law, Franklin Delano Roosevelt essentially ruled by decree. President George Bush basically, is a war criminal, and there have been no consequences. I think Trump is just the last in a long line of problems of rule of law. But I was indignant when I saw ICE agents in, it's one thing to arrest persons with criminal, illegal aliens with criminal records. It's quite another to just arrest people who may be in the country illegally, but who haven't broken any laws and are just trying to make a living. And I was just indignant about this. And as you can see, this was part of my original presentation. I've noticed, like, when this happened, I go, where have I seen this before? And so I've amassed here photos from the Irish Republican Army, ISIS, the Taliban, Hamas. I'm just outraged by this. But I have to say, and so my original talk, and then, the Supreme Court, through its shadow docket, really has decided to take a hands-off approach for now, Although, when you actually look at this in a big manner, a big picture manner, I think the courts are withstanding quite well. They're doing a pretty good job in pushing back. And of course, the history books have not been written yet on Trump 2 or Trump 47. But I'm a little bit more optimistic about this. And so ultimately, and so this is just by way of preface to my presentation, is why was I so indignant about wearing masks? And so ultimately, I want to use my talk to really step away from this precipice, and I want to identify three important puzzles involving the rule of law. One will be historical, one will be theoretical, and one will be empirical. Now, I promised my JLPP editors, and by the way, thank you for inviting me, and thank you for dinner last night. What a wonderful group of students. Professor Reed and Professor Cornell, I have to really commend you for what you've done, and Dean Kelly as well. So let's begin with, so I want to talk about these three puzzles. And by the way, I was looking at the Instagram page for the JLPP, and I saw, by the way, no one's mentioned the Magna Carta. But I saw on your homepage, you have the Magna Carta there, you have this exact image. And so my first historical was, how do we get the rule of law? And I would say, in Anglo-American tradition, we begin with the Magna Carta. One of the ironies of the Magna Carta, though, is that, if you look at the history books, it was extorted by force. And in this sort of romantic, idealized image, you see the guy wielding the Lord there, wielding the stick, and another guy behind King John wielding another stick. No, those were daggers, King John, in fact, he repudiated the Magna Carta as soon as he was able to, as soon as he was out of harm's way. So this kind of raises an interesting question. Of course, British history, is long. There were the English Civil Wars. More people died in the English Civil Wars when Thomas Hobbes was writing the Leviathan than in the First World War. It's by contrast, we have this great statement of the rights of the Declaration of Man, the French Declaration of Rights of Man, which were adopted democratically in 1789 when the three estates met in Paris. Yet unlike the Magna Carta, I hope you see where I'm going with this, right? The ill-fated French Declaration of Rights proved to be an ineffectual legal document, to say the least. One that failed to curb the violence of the Reign of Terror, a horrible time in human history, or prevent Napoleon's consolidation of power in 1799. My second puzzle is theoretical. What is rule of law? And if you actually go back to your notes or watch the recording of this when it's posted to YouTube, you'll see actually quite a lot of different definitions have been offered of rule of law. And, for me, I'm a little bit frustrated because the words rule of law are not only vague, trite, and overused. The concept of rule of law has so many possible meanings or conceptions that it can mean different things to different people. But that said, is it possible, from a theoretical perspective, to rescue this concept, from this critique? And I will say, I think if you retrace I'm going to throw in a little bit of history here. If we retrace the linguistic origins of the phrase the rule of law, we can nail down some salient meanings of this, and it actually goes back to 1885. It's actually quite recent, or quite late, depending on your point of view of how important the rule of law is, to the great Oxford Don, A.V. Dicey. And so Dicey himself actually identifies three different conceptions of the rule of law. One is that the rule of law requires a law of rules, and this has actually been discussed on this panel, as opposed to, rule by law, rule of law. Or to quote Dicey, and I'm quoting now, no man is punishable except for a distinct breach of law established in the ordinary legal manner before the ordinary courts of the land. In other words, the content of law must be clear, and its meaning must be subject to judicial review. It is the judges who get to decide whether the law is clear or not. By the way, this is already problematic because we don't even know how many federal criminal laws there are. Last time a census was attempted, and earlier in the morning panel, someone said, well, as long as you can, I think Professor Lee, as long as in principle, you can figure out what the law is, but I even doubt that's the case. Secondly, the rule of law is also aspirational in nature. No one, no matter how, and I identify with this one a lot, no one, no matter how powerful or rich, should be able to flout the law or buy their way out, so to speak, when they get into trouble. Or again, in Dicey's own words, every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to jurisdiction of the ordinary tribunals. But another way, the legal equivalents of papal indulgences are incompatible with the rule of law. I think our previous speaker on presidential immunity, raises some interesting questions about the second conception of rule of law. Thirdly, and I would argue most importantly, actually, the rule of law is procedural in nature, or to paraphrase Dicey, the general principles of law are, quote, the result of judicial decisions determining the rights of private persons in particular cases. On this view, philosopher kings are incompatible with the rule of law and must be banished once and for all. Instead, general legal principles and general legal rights and duties must be defined by judges in actual cases. And that, to me, there's an ultimate puzzle here with the theoretical side is, do these three different conceptions, and there are many others, what is the common thread? Or is rule of law some kind of a convenient shorthand for various things that we like about the Anglo-American legal system? I'm going to raise that there. That's something I'll explore further in my paper. Because I think it is important to have a good working definition of rule of law in order to be able to measure. And finally, I want to conclude on an empirical question. And so there's a wonderful book that I recommend to all students of rule of law by Judge Tom Bingham. He wrote a little book on the rule of law. And in the epilogue to his book, he concludes by describing, and I have the painting here, part of the painting, the allegory of good government, a series of 3 fresco murals painted by the Italian artist Ambrogio Lorenzetti in the 14th century. And here's how Judge Bingham really eloquently describes the painting. He does it way better than I can. In the Hall of the Nine in the Palazzo Pubblico in Siena is Ambrogio Lorenzetti's depiction of the allegory of good government. Justice, as always, is personified as a woman, gesturing towards the scales of justice held by the personification of wisdom. At her feet is virtue, also a woman. A judge sits in the center, surrounded by figures including peace. The allegory is flanked by 2 other paintings, illustrating the effects of good government and the effects of bad government. In the first, well-to-do merchants ply their, and I couldn't find a good quality picture of this, so I'm sorry. In the first, well-to-do merchants ply their trade, the populace dance in the streets, and the countryside is well-tended, yielding a plentiful harvest. The second, which is a very badly damaged right now, that painting, is a scene of violence, disease, and decay. With this visual description of this vivid allegory, Judge Bingham then asked the $64 question. What makes the difference between good and bad government? Or more to the point, what explains the difference between a stable, peaceful, and prosperous polity and an unstable, crime-ridden, and impoverished one? Or more specifically, what variables best explain the differences between, say, Australia and El Salvador, between Haiti and Japan? For Bingham, it is the rule of law. Alas, while this conclusion, I'll be the first to concede, is a plausible one, what if the causation is the other way around? That is, what if it is good government, that is to say, government that respects property rights, enforces contracts, and allows markets to flourish, that produce rule of law? Or, in the alternative, what if good government and rule of law are both caused by a third variable, like trust, religion, or cold winters? To the point, and I'll conclude on this note, correlation, of course, is not causation, for there are at least 3 competing and opposing explanations of the relationship between rule of law and good government. In any case, what Bingham doesn't mention when he describes Ambrogio Lorenzetti's masterpiece is that this work was commissioned by the Republic of Siena, a once prosperous city-state that would begin a long decline a decade after Lorenzetti completed his commission. The ill-fated republic came to an end in 1555.
I'd like to thank each of our speakers this morning, and I have questions for each of them, and I'll begin. 3 of my questions have a common theme, and that common theme is really the unaccountability in the present order of private power, if you will, of great wealth and private power. I'll begin with Professor Carey. And Professor Carey, the role of the Sultan, the sultanistic democracy. And you gave a number of examples of sultanistic democracies. But I'd like to identify that perhaps one common thread running through each of them is a certain comfort level between the Sultan and the moneyed interests in the particular realm. The Duvaliers never upset the moneyed interests, neither did Trujillo or any of the other examples you gave. In fact, there seems to be a comfort level operating between them, between the moneyed interests and the highly personalistic, sultanistic rule of these leaders. Professor Breeden, a couple of related observations. I'll begin with the rise, if you will, of an age of cynicism. We're living in an age of great, intense, pervasive cynicism. And one might push back and say, isn't Donald Trump merely making transparent what was developing under the in previous administrations? Sale of pardons by Bill Clinton, the contracts to Halliburton for the rebuilding of Iraq under George W. Bush, and so forth. And doesn't this then highlight what I think is perhaps our most pervasive problem? That is the rise of the rule of money as our highest value. Values, we used to have a set of intrinsic values, respect, aesthetics, great learning. We used to have we used to have intrinsic values that stood over and apart from a dollar and cents calculus. But with the emergence of the rule of money, hasn't this in fact simply contributed, bred really the present crisis? And Dr. Malambo, again, we see it is the rise of China's idea, a principle of respect for state sovereignty, non-interference in democratic processes. Isn't the flip side of this again a kind of comfort level with economic elites that in fact this serves the interest of economic elites? And Professor Garapujol, a very different set of observations for you, and that is the rule of law. And I'll push back on Dicey. I think you can go back to the 13th century and find Henry Bracton saying that the rule of law exists in the idea that the king is under the law and subject to the law. And that's the 13th century. But to bring this up to our present situation, doesn't the rule of law depend on stable institutions? And once we destabilize or illegitimize institutions, have we thereby also destabilized or made less legitimate the idea that there is an impartial, autonomous rule of law that stands apart from politics, and that we should, in fact, all of us, regardless of partisan affiliation, all of us should give respect to? Now, those are my observations and questions. Professor Carey, do you want to respond first?
Sure. I think you've, in citing the ideal types of authoritarian sultanistic regimes, such as mentioned Haiti and the Dominican Republic and Central African Republic and others, you pointed out that the regime accommodated itself to the economic power structure. And I think that judgment holds up. But the rhetoric often targeted individuals to create enemies. And I think, for example, in the case of Francois Duvalier, he rose as a black power candidate against the mulatto elite. And the Haitian elites historically been divided between light-skinned people who had other inheritances, especially whites, but also Middle Eastern elites as one business class. The mulattoes were also more predominant in the south of Haiti than the north, where the generals and the darker skinned people were located. Duvalier ended up using his arbitrary coercion and assassinations against anybody who opposed him. And that what's made it a pure sultanistic regime, is if he thought she was opposed him, you were dead, or if he wanted to intimidate poor peasants on the border region, he would assassinate many and hold them up as an example of what could happen to you if you crossed him. So, yes, there were many mulattoes who were assassinated and killed who were part of the former economic power structure. But there are also mulattoes who survived under Francois Duvalier as an example. So there are lots of nuances and subtle differences in what the pure sultanistic regimes do. In the case of Donald Trump, he hasn't resorted to coercion in terms of targeted assassinations, except overseas. And we'll see, what could happen with the use of the military and the use of power. So far, the military in cities have been reportedly not using force arbitrarily. It's mostly been ICE and the border and patrolling individuals that have come often on unmarked secret police type deployments, similar to what he used to clear the Lafayette Square in July 2016 when he was running for president. In 2020, when he used unmarked police people. But these aren't targeted assassinations. So I think the combination with economic elites under the Trump administration, both the first one and the second one, is clear. But there have also been enemies who've been created among the elites who are not personally loyal and tried to stand up to him. This doesn't result in murder, of course, but it has resulted in various forms of retaliation and marginalization, including enemies lists, tax audits, lawsuits, personal and private, and so forth. So we'll see how this plays out, and it's not an ideal type in practice with this sultanistic democracy, but it shows the extreme influence of money and patrimonial policies which treat the state as personal property of the ruler. That has the similarity with some of these pure forms that you alluded to.
Thank you. Professor Breeden.
Yeah, hi. So thanks, Dr. Reed, as always, for your insightful and thought-provoking questions. So I sort of took your comments as directed toward me at any rate, as raising a couple of different issues. One, as you say, being the rise of the age of cynicism and whether Trump is merely making transparent what previous administrations have done behind the scenes. And I think to some extent that's true. To some extent, what we're seeing is simply a difference in degree of the willingness, particularly to run afoul of international law. But I think that prior administrations felt more constrained by domestic law than this one does. But I also think that we are seeing a difference in kind. I think that we have not previously seen an administration willing to exercise the levers of governmental power to line his own pockets in very extreme and blatant ways. So yes, I think to some extent the emperor has no clothes when it comes to what the chief executive does in pursuit of political gain or personal gain. But at the same time, I do think that we're seeing something different here. And it is related to your second point, which is the rise of the rule of money. And I think I'm on the record in many instances as decrying some earlier Supreme Court decisions which have allowed the use of money to corrupt, for lack of a better term, not only our individual representatives in some instances, but also entire institutions. And so, yes, I do think the rise of the rule of money has certainly contributed to the present crisis. And I think you're starting to see a return to some rhetoric by journalists and some public accountability organizations and some members within the public to a call to supposedly, overturn Citizens United. I don't think that goes far enough. I think that this particular Supreme Court would probably find any legislative efforts to overturn Citizens United also to be unconstitutional. So I think probably a constitutional amendment to get money out of politics is going to be essential if we want to pull back from the precipice of the rule of money. With respect to foreign interests paving the way for their own national interests by corrupting our legislators or chief executive. Some operationalization of the emoluments clause, both clauses actually will be in order. And I'm just not entirely sure that our political class either recognizes the needs or is willing to make the sacrifices that need to be made in order to address those needs. So I think ultimately the power of the people will have to come into play. We'll have to start holding our representatives accountable in ways that we don't currently. I think getting to the underlying question about bipartisanship, particularly with respect to corruption, it's critically important that if we're talking about partisan political parties, members of each party have to be willing to hold their own accountable. You can't just call for accountability for corrupt practices when it's the other party's representatives who are engaging in those practices. You also have to hold your own party accountable. And, there's a mixed record on that front. So the bottom line is, yes, I agree with you. I think that to some extent we're seeing just a difference in degree, but I also think we're seeing a difference in kind. And I also agree that the rise of the rule of money is one of the contributing factors to our present democratic backsliding.
Thank you, Professor Garapoohol.
Well, thank you for the question. And again, I'm in this enviable position, but I have a couple of by the way, thank you for the reference to Henry Brockton. I am certainly going to go back to that. And I think there may even be some fascinating canon law references as well. And so it's really going back to Dicey's work and seeing what sources he consulted and what sources he may have overlooked. But to your $64 question, to my $64 question on what causes good government. That is a very fair point. Stable institutions are an important component, you could say, of good government. To the extent we delegitimize these institutions, right, we could be then shooting ourselves in the foot in a bigger picture sense. I will only, and so this is something I will grapple with in my paper in the spirit of good intellectual, honest exchange. But I will make 2 points just for now, tentative. One is we have something of a paradox where many of our institutions, the administrative state, and here I'll push back on Professor Rudisell's presentation, can arguably be a point be made that they're completely inconsistent with whatever conception of rule of law we have in mind, because the same agencies that are making the laws, rules, get to enforce those rules and get to judge those same rules, as well. Now, admittedly, there's a judicial review is available on the back end, but as we saw in a previous presentation on celebrity and defamation lawsuits, sometimes having back end remedies in the courts may or may not be effective. The other point, more micro point that I'll make is that, and this is a fair question, what causes good institutions, right? And what makes institutions stable? What makes them good? And that is a fair open question, one that I'll have to if not go back to the drawing board, at least give some additional thought to. Thank you. Thank you again.
Thank you.
We'll open the floor to any questions any of the guests may have.
Just terrific panel. Really, really enjoyed it. So with regard to Professor Carey, I don't know if we still have him, but I just wanted to offer a additional point to his observations about the first Trump administration. He identified Vice President Mike Pence and General Mark Milley, Chairman of the Joint Chiefs of Staff, as essentially saving the rule of law by their decisions after the 2020 election. And I just wanted to just kind of qualify that a little bit by saying that I think that certainly what the Vice President did reflected constitutional conscience in a very significant way, and I think General Milley as well. But the first point I'd make is I don't think there's actually any evidence that Milley refused an order. I don't think he ever got an order. I think that he was enormously concerned that the president would try to generate a conflict of some kind that would justify staying in office, and there were a lot of people around the president who wanted that, but I don't believe he ever got an order. The second thing I want to know is I think that equally important to whatever Pence or Milley did actually was the lawyers. It was the lawyers that President Trump had appointed to lead the Justice Department and to be in the White House counsel office, who in a number of meetings with senior administration officials and especially a number of Oval Office meetings pushed back on a lot of the claims that were being made. Very, very well documented by the J6 committee, which overwhelmingly interviewed Trump appointees. The tapes are there and the transcripts, and it's just a very, very well written report, and very, very clear that they pushed back on the stolen election claim. The White House counsel saying, okay, it's time to put up or shut up. You've lost over 24 cases now, right? You're a billionaire and you've got the DOJ and you can't find evidence that ever holds up in court, right? I mean, like just being a lawyer, just saying like, okay, fully, the process is here, and we just keep losing over and over and over again. We just have to respect, anyway, they're just like doing their lawyer thing of just like looking at the process and the results. Anyway, so, we're at a legal conference, so I just want to underscore, like the lawyers, I think, were just enormously impactful for that. And then as we think ahead to the second administration, I think very, very clearly for Vogt and a number of other people, they want to prevent that ever happening again. I mean, Vogt has been very, very clear. He never wants a situation where there's a lawyer in the Oval Office telling the president he can't do something, right? Even if it's use of force domestically, Vogt has said he does not want somebody telling the president no. And I look at that, and again, from a legal ethics standpoint, from a rule of law standpoint, I'll be gentle and say that's a dramatically different direction than we've had. So, thank you.
Thank you. I just wanted to say, first of all, I mentioned with respect to the Mark Milley situation that the evidence was ambiguous. And my point in bringing up the example was just to say that he might have saved democracy. But that's not really the overall point I was trying to stress is that there are forces pulling and tugging in one direction and then in the other throughout this hybrid sultanistic democracy ideal type that I presented. And regardless of whether Bob Woodward's account of that episode is correct or partial or impartial or biased, the point is that it took people that could have saved the democracy or ended democracy just by their mere decisions in a great moment of crisis. And that's the larger point, the survival and the tendency of the trajectory to go in a sultanistic direction away from the rule of law depends on these key individuals. If they happen to be lawyers, that's great. Lawyers are some of the great gatekeepers in this process. They're not the only ones. And there are many people who at key moments can save democracy or destroy it.
Thank you.
With that, I'd like to give a round of applause for this great panel. We will be taking a short break.
Now we're getting the thumbs up.
All right, everybody. We're going to get started on our keynote presentation for our symposium. I'm excited to present Raj Bala. He is going to be presenting on Law and the Human Condition, Shakespeare's Lessons on Justice and Moral Order. Raj Bala is a University Distinguished Professor at the University of Kansas School of Law, the first in the school's history. A leading scholar in international trade law, Islamic law, and law and literature, he has authored major works including Modern GATT Law, Trade War, Causes, Conduct, and Consequences of Sino-American Confrontation, and Understanding Islamic Law. Before entering academia, Bala practiced at the Federal Reserve Bank of New York and represented the United States at the United Nations Commission on International Trade Law. Recognized as one of 50 Kansans you should know by Ingram's Business Magazine, he is an internationally respected voice on global trade, law, and ethics, and has taught and lectured around the world. So if you'll please join me in welcoming our keynote presenter, Raj Bala.
Well, it is a true honor and pleasure to be with you. I am sorry I can't be with you in person. I know you've been having a great time because I've been listening in to this morning's proceedings, and congratulations to really what were a series of fantastic keynote presentations. So I'm just following in the footsteps of the earlier presentations this morning, and I'm able to do so because of the wonderful preparation that's by Denley Wenner and Anna Larson and Jackie Moen. And of course, very much by my dear friend and my really a mentor, an intellectual mentor, Professor Charles Reed, Chuck Reed. I really owe so much to Denley and Anna and Jackie and Chuck. This has been a long time in the making. And of course, it's very timely. It is day 306 of the second Trump administration. I've been spending much of my time in these first 306 days working on two 100-page law review articles that will be coming out in the Texas International Law Journal on the violations, disruption, violation, shattering of international trade law, a topic we heard about this morning, very ably this morning. The violations of the GATT Article 1 MFN rule and GATT Article 2 tariff binding rules, and whether or not there are any legitimate exceptions like national security in GATT Article 21. So I'm not going to talk about trade too much today. That's been there, done that recently, and probably will be doing that for a while. And there are other venues where we can discuss that. What I'm really excited to talk about today is a paper that I'll be offering for the symposium, which is called Applying the Rule of Law to Shakespeare's Measure for Measure. Applying the Rule of Law to Shakespeare's Measure for Measure. Now, this article basically deals with Shakespeare's 1604 play, Measure for Measure, and it argues that the play is all about the rule of law. From beginning to end, the play presents both secular and sacred legal issues, and the trade-offs that can arise and do arise in the everyday lives of everyone on stage, everyone reading the text or viewing the drama. That's all in this play. And the article identifies and analyzes the legal and related moral problems of this play, which is not by accident entitled, the only one of the 38 Shakespeare plays. It's the only one entitled after a biblical passage, which we'll probably talk more about. Now, for this kind of thesis that Measure for Measure is through and through a legalistic play, arguably the most legalistic of all of Shakespeare's plays, what do we need? Well, we heard this come up this morning, a definition of the term rule of law. So I'll spend some time on hallmarks of this term and draw on some ancient and some medieval and some modern sources. So we have a common discourse on what rule of law means. And then I'll offer some helpful background about the play itself. And then finally, apply those rule of law elements to the conduct, the acts and omissions of the leading and some of the minor actors in the play. Now, I'm privileged to teach not only international trade law, but also law and literature. And it's my law and literature is actually my highest enrollment course at the University of Kansas. It's basically about 40 students. And that is notwithstanding the fact that this summer, for the first time, I assigned summer reading. I said, if you want to take the class, you got to read Measure for Measure and Julius Caesar. And the enrollments went up. I wanted everyone to have, background in these plays. And we do about 6 more Shakespeare plays and apply legal themes to them, consider the legal themes in them. Now, I realize that not everyone may have read Measure for Measure. So before kind of diving into these different parts of the article, the rule of law and applying the rule of law to the play, bear with me, or hopefully you'll enjoy a plot summary, just a plot summary. Now, this plot summary is taken from the Royal Shakespeare Company, Shakespeare's A to Z, the Oxford School of Shakespeare, various sources. Now, I'll just kind of go through the 5 acts of the play so we all have a common understanding. And what you might like to do, I realize it's after lunch, but you might like to start spotting issues, rule of law issues, as I go through the facts. I always think that Shakespeare plays are a factual predicate. I mean, Romeo and Juliet, it's a crime scene. You can give that in criminal law. King Lear, that's great for trust and estates planning. Well, Measure for Measure is all about rule of law. So you can start seeing some rule of law issues, spotting them as they go through. So we got Act 1. And I'm also going to tell you, in a lot of cases, the setting of each of the scenes. So, because Shakespeare is very good about alternating and juxtaposing settings. So in Act 1, in Scene 1, we are in a judicial office. We are in the office of the Duke of Vienna. Vincentio is the Duke. And he's going to leave. He leaves Vienna. And he deputizes one of his 2 junior ministers, Angelo. The other junior minister is Aeschylus. And the Duke deputizes Angelo with the Duke's executive authority in his absence. So this is sort of like the 26th Amendment in operation. The Duke instructs Angelo to enforce the laws of Vienna, including the law on unlawful sexual intercourse, adultery or fornication. It carries the death penalty in Vienna. Now, none of these laws, including the one on unchaste behavior, has been enforced for 14 years. So we then switch in Scene 2 of Act 1 to a brothel. And we have Mistress Overdone. And she is the proprietor of a brothel. And she informs Lucio, who's a witty bachelor, and he's a friend of Claudio, that Claudio has been arrested for engaging in sex with Claudio's fiancée, Juliet. And Juliet is now pregnant as a result of that liaison. Lucio, Claudio's friend in the brothel, is shocked to learn from Mistress Overdone that Claudio is going to face the death penalty per the laws of Vienna. The bartender in the bar, in the brothel, Mistress Overdone's employee, Pompey, he's the bartender, he brings some more bad news. He said the Viennese government has ordered the destruction, the closure of all the brothels. In this crackdown, this moralistic crackdown, the brothel is going to be closed. But he also says humorously, "Don't worry, you won't lack any clients. You're really good at your profession, Mistress Overdone." Scene 3, we turn to a prison. In the prison, Claudio is presumed guilty by Antonio. He's been presumed by Antonio guilty. And Claudio has been paraded by the provost, the prison warden, through the streets of Vienna to the prison where we are now. And Claudio's got no meaningful right of appeal against this swift conviction and pronouncement of judgment. The Duke is absent, and in any case, Antonio is both the political and judicial leader of Vienna. Claudio's not officially married to Juliet. The arrangements for her dowry have been not fully secured. They've not been transferred yet. Only for this financial reason, they're not fully married. But they have declared in the presence of witnesses that they will be married. They want to be married. They will be married. And they've signed the documents. They've exchanged some vows. So under Elizabethan law, actually, we would call this a pre-contract. And they are entitled to cohabitate and sleep together. but they're not yet married in the eyes of the church. In scene 4, we turn to a monastery, scene 4 of Act 1. And the Duke asks a man of the cloth, Father Thomas, to hide him in the monastery. And the Duke says, look, Vienna's become really corrupt. We haven't enforced our strict statutes and most biting laws for 14 years. So we need to begin enforcing these laws. But I don't want to be the guy who enforces them because I'll be thought to be a tyrant because I'll be forbidding behaviors that had long been tolerated. So the Duke says to Father Thomas, I've charged my deputy Angelo with the enforcement. And in the meantime, would you please give me the monastic garb so I can be disguised as a friar and I can spy on Angelo, my deputy, see if he has been precise, has he been strict in enforcing the laws of Vienna, and let's see what the citizens of Vienna think of this enforcement. That's the end of Act 1. In Act 2, we go back to the courtroom judicial office, and we have the second of two deputies of the Duke, Aeschylus. He's the more moderate, temperate one. Angelo is obviously, as you're going to see, the very strict one. If there's going to be anyone who tempers justice with mercy, it's going to be Aeschylus. But so Aeschylus says, hey, Angelo, come on, you're really going to execute Claudio for having technically unlawful sexual intercourse with his fiancée? And Angelo's, hey, yes, uncompromising enforcement of the law. And then Aeschylus says, well, wait a sec, what if you committed the same thing? And then Angelo says, I should then be put to death too. Anyone who succumbs to this temptation should be punished. This is a Christ-like standard Angelo is establishing to resist temptation. And he's putting this resistance into secular law. Then we have, because Shakespeare's good at kind of mixing the very serious with the hilarious, we got a police constable, his name is Elbow, and he brings in two male prisoners into this judicial office, this courtroom. A fool, a guy named Froth, and Pompey. Pompey's our bartender from the prostitution den. And Elbow, who's the police constable, confuses them. I mean, it's a hilarious argument about who's who and who's guilty of what. And he's overworked. The judicial resources are strained in Shakespeare's Vienna. In Act 2, Scene 2, we turn to the judicial office, and we're in the courtroom again. And the courtroom, the provost of the prison disagrees with capital punishment for unchaste behavior. He says, Angelo, why are you doing this? Why do you insist on executing Claudio? And Angelo again is like, we got a job to do, and we're going to do it. And so the provost says, well, what about Juliet? She's pregnant with Claudio's child. And Angelo says, well, have her removed to some fitter place for the time being, which is in fact another prison, just different from the one where Claudio's jailed. And then Lucio and Isabella. Isabella is a novice nun. She wants to become a nun. She's in the process of becoming part of the Poor Clares, Sisters of Poor Clares. They come in the courtroom. And Isabella is the sister of Claudio, the condemned man. And Isabella says, I detest the crime of my brother. But please, Angelo, don't punish him. To use your powers like a giant would be tyrannous. And Isabella says, I will pray for your soul, Angelo. Angelo says, come back the next day. And we start to suspect what is true, that Angelo himself is sexually attracted to this novice nun. In scene 3 of Act 2, we're back in the prison. And now we have the Duke. He's disguised as Friar Lodovic, and he sees Juliet in prison. And he asks, do you repent your behavior? And now she doesn't know that he's not really a priest, right? And he's asking her all these intimate questions. And she says, yes, but I love Claudio as much as I love myself. Second commandment, right? Second great commandment. The disguised Duke casts doubt on her affirmation. And she says, you're only saying that because you're pregnant. In scene 4 of Act 2, Angelo is really struggling with his lust for Isabella. He tries to conceal it, but she comes into his office, this place of law, and she says, I seek to know your pleasure, which is kind of humorous because she means wishes. I want to know what you want, but he's misinterpreting that in a sexual manner. And Isabella then says, hey, can you do anything to spare my brother? And he asks her what seems to be a hypothetical question. Would you commit a sin to save Claudio? She's still clueless, this novice nun. She's still clueless about Angelo's true intent. Now he makes the quid pro quo explicit. If you will lay down the treasures of your body, I will save the life of her brother. Now, this is an old folklore theme of the corrupt judge saying, if you give me, interested party, what I want, I will do what you want. And of course, you know what's going to happen. The corrupt judge is not going to fill his end of the quid pro quo. She's shocked and mortified by this corrupt proposition. And she says, I'm going to tell the whole world what you have just proposed to me. And he says, no one will believe you. You're a woman. And I have the sound reputation. I'm a man and I'm the deputy. You're just a woman. So no one's going to believe you. Isabella actually concedes that point, that she probably won't be able to persuade the Viennese public that Angelo's corrupt. So she goes to the jail to visit Claudio and tell him what happened. And so then we turn to Act 3. We've again got this disguised friar, the Duke, and he visits Claudio. And he says, you know what, Claudio? I'm going to prepare you for death. Life is not worth living. You should be thankful you're going to die, because if you lived, all you would do is grow old and get diseased and suffer. And Claudio thinks, okay, that's probably right. I will welcome death. Again, this is not really a priestly counsel, right? Because this is not a true priest. And Isabella then shows up in the prison. The Duke, disguised, right, hides. He eavesdrops on this sister-brother conversation. And Isabella says, Claudio, it looks like you're going to die, but there is one way out. There's a wicked offer I've been given by Angelo. Claudio says, I'm outraged. You must reject the offer and proceed for your vocation as a nun. But then he quickly reverses course, with sensing death so clear, so close. He says, Isabella, you should sleep with Angelo. To save the life of your brother would be no sin, right? So you clearly got an interesting value choice there. Isabella curses her brother, calling him a faithless coward. And she basically departs. The Duke re-enters. There's some conversation there between Duke and Angelo about the Duke and Claudio. And the Duke concocts a plan. I, the Duke, can save both the virginity of Isabella and the life of her brother Claudio with what is the bed trick. Now, the bed trick requires the collaboration of a woman named Mariana. Mariana is the once and maybe still fiance of Angelo. Angelo and Mariana were engaged to marry, but their marriage plans were broke off when the ship carrying Mariana's dowry was lost, along with Mariana's brother. With the bed trick, also drawing on folklore, the idea is Isabella will agree to sleep with Angelo, but they'll substitute Mariana, the fiance or ex-fiance of Angelo, in the bed, under the cover of darkness, and Angelo will think he slept with Isabella. In fact, he's sleeping with her, with his fiancee or ex-fiancee Mariana, and then Angelo will be satisfied and he will free Claudio, and this should work. And in fact, it'll consummate, if you will, the marriage of Mariana and Angelo, and there'll be nothing illegal about it. Well, okay. Now, skipping on a few scenes, so in the interest of time, there are a couple of funny scenes involving Pompey, and we then get to, in Act 4, the moated grange, kind of like a garden type scene that we see in some of other Shakespeare plays, a place of happiness, where Mariana, for bizarre reasons that Shakespeare never really outlines, we can probably speculate, she still loves Angelo. And she said, yes, I will participate in this scheme. I think it's a good idea. So the bed trick proves successful in that by Act 4, Scene 2, Angelo has slept with Mariana, believing her to be Isabella, and Claudio is being prepared for execution. And there's some amusing scenes there where Pompey is made the assistant executioner. Now, there's another trick, also drawing on folklore, that the Duke concocts. So the Duke is not all a bad guy, even though he's disguised as a priest, a friar. He concocts this head trick, and the head trick is this: the prison warden has basically been promised Angelo, and the prison warden has promised Angelo that the head of Claudio will be delivered to you today. Well, we'll just substitute heads. We will execute Barnardine, who's a prisoner in the same prison, and we'll give Barnardine's head, and you won't know, and Angelo won't know the difference. And so everyone's agreed on the head trick. So two tricks: bed trick and head trick. Well, in a comedic scene, Act 4, Scene 3, in the prison, Barnardine says, I'm not going to be executed. You can't execute me. Why? Because I've been drinking all night. And I still want to drink some more. I'm not ready to die. I'm going back to my cell for more sack or wine or beer or whatever. So the condemned Barnardine is saying, I'm just not ready to be executed. He tells the warden this. So, okay, so now we need another head, right? So let's find another head. And it turns out there's a pirate named Razadine. He died of a cruel fever. They use his head. They deliver that head to Angela. Now, the culminating Act 5, the final, like most Shakespeare plays are 5 acts, basically this is the longest, only one scene, but everything comes to a head. Basically, the Duke re-enters Vienna in a very ceremonial manner, and he is ultimately revealed as the Duke, shedding his priestly garbs. And he has arranged for Isabella and Mariana, the two women whom Angelo wronged, to offer their complaints publicly against Angelo, that Angelo has committed concupiscible, intemperate lust. So they do that, basically. And everyone is, horrified. What is it? Angelo, my gosh. And Angelo realizes his plight. He confesses to his unchaste behavior, and he says, I should suffer the death penalty. Well, the Duke, appearing as himself, says, you know what? That's not the sentence I'm going to pronounce. We got a different sentence for you, Angelo. You got to marry Mariana. And that's what ends up happening. And the Duke, shockingly, proposes twice to Isabella, this novice nun who thought now she could go back and resume her life, training as a nun. And we never know, for the last 50 or 75 lines of the play, we never know Isabella's reaction to the Duke's proposal. Now, of course, we've got an power asymmetry here, a male Duke and this novice nun. I've always thought, you look at the different ways the play has been staged, how would you script Isabella's face when she hears this proposal from the Duke? Is she happy? Is she sad? Is she just shocked? And different directors will script it differently. And we also get a third marriage, in addition to Angelo Mariana and possibly the Duke Isabella. The Duke says, hey, Lucio, you're not off the hook either. You got a woman pregnant in the brothel. She's now had a son. You better marry her. So the play ends problematically, and surprise, surprise, this is one of Shakespeare's problem plays, along with Troilus and Cressida and some others. And so we don't know if these are happy marriages or not. So that's a thumbnail sketch of the play itself. And that's our fact pattern. So now we sort of turn to this question, well, all right, if we're going to identify or spot the rule of law issues in Measure for Measure, what's our definition of the rule of law? And in a wonderful 2006 presentation in Kuala Lumpur, Justice Anthony Kennedy, and I'm going to draw a lot on his paper, as well as some other sources, mentions that the term rule of law is often invoked, yet seldom defined. There are risks in attempted definitions. There's a risk of saying too much or too little, of prolixity, which defeats the allure of short definition, of a summary so facile that discovery of truer principles is inadvertently foreclosed. So he goes on and on. I'm going to offer, based on a couple of ideas that date back to Aristotle, some hallmarks of the rule of law. Aristotle is not he's sometimes described as the first paladin, the first hero or champion of the rule of law. He doesn't actually use the phrase or define it. But what he does do is give us two helpful taxonomies. The first is, what's the type of political regime or form of political organization that is governing? And he identifies monarchy, that's one person governing. He identifies aristocracy, a few people who are privileged elites governing, and then he identifies the polity, a multitude governing. And he says each one of these has a degenerate type or degenerate regime type, and that's tyranny as against monarchy, oligarchy as against democracy, privileged elites or aristocracy, and democracy against polity. And Aristotle also deals with the question of written law. There's a term in ancient Greek, kala grammata, written law. And he asks the question and never answers it. Is it foolish to be governed always with rigid written laws? Or sometimes should written rules be adaptable and flexible? And he goes through and discusses in the politics both sides of that question, and ultimately actually concludes with virtue ethics. Now, another area we get, and we heard about this we heard this in the discussion earlier today, where we get some inspiration for a definition of rule of law is, of course, the Great Charter, the June 1215 Magna Carta, where we get, it's a peace treaty. As we heard, King John wasn't too happy with it and got out of it as soon as he could. But it does establish the idea of accountability, that any definition of the rule of law has to have some feature of accountability, that there are rights against the king, rights against the ruler. So that's going to be another piece of our analysis. Then, and I realize I'm skipping a lot of great thinkers, so forgive me, John Locke, and we get restraint. That in what we now look retrospectively, because Locke didn't really address Hobbes directly, kind of pretend he didn't exist, that rule of law involves some consent of the governed who are going to give up some measure of freedom of their property rights from the state of nature, and they're going to do so because rules are properly promulgated and established by a sovereign who is himself or herself restrained. So we've got accountability from Magna Carta, we've got restraint and its features of consent and promulgation and establishment. And then we come to another great name we heard, Albert Van Dicey. I would hesitate to point out that he was against Irish Home Rule and he was against women's suffrage. So those are, but we'll put that aside and we'll say, all right, he talked about constitutional structure, and three features he identifies as part of the rule of law in his constitutional structure are going to be the supremacy of Parliament. Parliament is sovereign, and an equality of all before the law, and that the judiciary is free from interference. So you've got basically Parliament is sovereign, and the judiciary is going to be free from interference. And then I meant to say, and the common law is supreme. So nobody's above that common law. That's the equality piece of the equation. And now we come in modern times to Justice Kennedy in his speech in Malaysia in 2006. And he says, really the rule of law in his vast experience comes down to fidelity to three principles. Superiority. The law rests on principles that are acknowledged, that bind everyone. So that is similar to Dicey's idea of supremacy of the common law. Second, the law must be just. And Kennedy really defines justness in terms of the dignity and the quality of all persons. I mean, he doesn't expressly say this in Malaysia, but basically, we're all made in the image and likeness of God, and we're all entitled to equal human dignity, and the law, secular law, should respect that. And third, the law must be enforceable. In like cases treated in like manners, and it should be enforceable in a predictable manner. Okay, so we got the facts. If you're thinking IRAC method, issue, rule, application, conclusion, you got the facts, right? We know we've got what the rules are on rule of law, and now let's sort of apply some of these rules to this one play that, again, I said is based on the only title based on the Bible. That title comes from Matthew's Gospel, chapter 7, verses 1 and 2. Judge not, and you will not be judged, for with the judgment you pronounce, you will be judged, and with the measure you use, it will be measured to you. And we know, of course, from Shakespeare's biography at the King's School in Stratford, he was well schooled in the Bible and the classics, so this was not an accident that he titled Measure for Measure in this way. I'll skip over the part of the paper that asks whether this is a comedy or a tragedy and why it's sort of a problem play. But I would point out simply this, that if we think about arc of character, in a tragedy, we expect characters to grow in wisdom, and then in retrospect, when they look back, they're sad, they regret. And in comedy, we also expect some growth of character. The arc of character points upwards, but it's comedic looking back. They can laugh, right? The marriages all work out well. It doesn't end in a grave or three bodies on a bed dead like in Othello. Well, I was reading about the new book that Pope Leo has written, and he quotes from St. Augustine. Of course, he would have, being an Augustinian. And he says, let our lives be good, and the times are good. We make our times. And I find that so inspiring, given the times we're in. And I also was applying that to the characters in Measure for Measure. If their lives are good, the times in Vienna will be good. And yet their lives somehow aren't good. They don't make good times. Their arc of character seems flat or even downward sometimes. So perhaps that's why we can say it's a problem play. Now, in thinking about some of the characters, and we won't have time to go through all of them. I realize should stop in the next 10 minutes or so. But let's start with the Duke of Vienna, Vincentio. Well, what form of Aristotelian political regime does Shakespeare present in Measure for Measure? Monarchy, in the person of the Duke and the person of his two deputies, Angelo and Aeschylus. The risk that Aristotle identifies about a single ruler making decisions and the risk of rigid rules, written or perhaps unwritten, are very apparent. One man is judge, jury, and executioner, and not necessarily based on a dispassionate view of the law, but his interests in the law, his own passions, as we see with Aeschylus and Isabella. And Aristotle leaves us with a distinction between rule of law and rule by man. Rule of law and rule by man. And if you think about Vienna, neither of those perfectly characterize Vienna, Shakespeare's Vienna. The answer is kind of in the middle. We get some rule of law, but then man steps in, and it's the man who's really deciding what's happening. We see that with some great quotes from the Duke and from Angelo. We also see in the Duke the principle or lack thereof of the Magna Carta and accountability. There is no accountability here for this Duke. He can disguise himself as a priest. He can show up wherever he wants. He can pronounce that I won't apply the death penalty. Instead, you're going to be married to whoever I say. And thus, we also see Justice Kennedy's idea of the superiority of the law lacking in both the person of the Duke and Angelo, and a lack of justness. We've got this unjust quid pro quo that's happening that in throughout the play. No, so people are above the law, including, of course, the Duke. What about Angelo? Well, we can think a little bit about John Locke and consent and promulgation. Nothing really that Angelo does is properly promulgated or consented to. He just starts enforcing these laws that haven't been enforced. And here there's an irony. Shakespeare names Angelo, but if we think about the ancient Greek, it comes from Angelus, which means messenger. But this Angelo in Vienna bears no resemblance to the biblical archangel Gabriel, who delivers, of course, the Annunciation message and messages to protect the Holy Family from the perils of King Herod. Shakespeare's Angelo is a messenger for the Duke, and with deeply problematic substance and style in delivering his message. So we never get properly promulgated or established true rule of law under this deputy Duke. We also see, in terms of Dacian constitutional structure, that Angelo affirms Dicey's idea that he should be subject to death. No one would be above the common law, if you will. And then he reverses himself and says, yeah, I'm above the common law because with Isabella, in the encounter with Isabella, he says basically this evil quid pro quo, and I'm going to just do what I want. And then reversing himself again in Act 5, when he's confronted with his transgression, he's racked with guilt, and the law is supreme again. So you kind of see Dicey's principle of the supremacy of the law, albeit not common law, affirmed, reversed, and then affirmed again. And similarly, in the interest of time, we can analyze Angelo's behavior through the lens of Kennedy and the superiority of the law. When we turn to Isabella, we see Kennedy's principle of justness, and here it's mercy. And you might remember from The Merchant of Venice in Act 5, Portia delivers one of the most beautiful monologues in the courtroom. She's in disguise as a male because women can't argue in court at the time. On mercy, droppeth from heaven, and it's twice blessed. It blesses the person who gives mercy and the person to whom mercy is given. That's a great speech in court. It's rehearsed. She's thinking about it in her mind on the way to the courtroom, presumably. But when you look at Isabella's plea for mercy on behalf of Angelo, the man who wronged her, why on earth would she want him not to die? And yet she makes this plea in Act 5 before the Duke. Some Shakespeare scholars say Isabella's plea is actually the greater of the two speeches on mercy. I love her presentation because it's Justice Kennedy's point about justness, and it's not always the strict application that's the best. Let me then bring the presentation to a close, and with the paper goes through many more of the characters, including Mistress Overdone and Friar Thomas and Friar Peter. And just let me conclude with this point that I think one of the happy or comforting, let me say comforting things on day 306 of the second Trump administration is to return to the canon, return to some of our literary roots and realize what we're going through now is not unique in history. Shakespeare wrote about it 400 years ago. And he did so with potency and poignancy and good humor as well. And if we can read those plays again, reread them, rediscover them, and think about what the rule of law means, issue spot through the plays, I think we learn a lot. And it's for good reason why Samuel Johnson declares Shakespeare not to be of an age, but for all ages. So with that, I thank you again. And again, a special call out to my dear friend, Professor Chuck Reed.
Professor Bala, thank you so much for your presentation. May I ask you a question? And that is about the Duke. And may I use an old form of interpretation, allegory? What does the Duke stand for? And I will propose an allegory. And the allegory is this: he fluctuates. He fluctuates. At times he stands for the rule of law. At times he stands for a kind of personalist, if you will, arbitrary, capricious set of not quite unlawful actions, but paralawful actions. Is he really an allegory for the state, for rulers within the state? How do we see him if we decide to put on our allegorical cap and really, as St. Augustine did? St. Augustine was the great use of allegory. If we decide to let our imaginations run and ask ourselves allegorically, what does the Duke stand for?
I love that question. Thank you for it. And Shakespeare scholars have debated it through the ages. Another reason why the play is a problem play. And my answer, which may be a bit satisfying, is if we phrase your question as a multiple choice question, the correct answer would be the last one, E, all of the above. If you draw on the different Shakespeare scholars, they will say that E is an allegory for the rule of law, but also an imperfect allegory because, as you rightly say, he has his own interests at stake. He's spying on his own people. He's a coward in terms of enforcing the rules. He uses someone else as the stick. Then he's got his own interest with Isabella. He's preventing her from the higher calling of going to a religious life. And yet, he's not a dreadful guy. I mean, his punishment of Angelo and righting the wrong that Lucio did against the prostitute in the brothel, if you will, those aren't bad ideas. He is a complex figure, and maybe he's a reminder that he's an allegory, an extended metaphor for how we look at some of our own rules. That maybe he gives us some pause to say, hey, I'm not going to quickly pigeonhole and judge a person. I'm going to instead, be a little bit more careful and thoughtful about the complexity of this individual. I apologize if that's not what I would suggest.
Professor Bala, thank you. Thank you so much.
Thank you very much, Professor. We will take a 10-minute break before we get into our fourth and final panel.
Okay, we're going to get started with our final panel of the day on constitutional strains safeguarding the rule of law in American governance. Our first speaker is Isaac Adelakun. Mr. Adelakun is an emerging voice in African and global historical scholarship, currently pursuing an MA in Africana Studies at the University of Delaware. With a foundational background in history and diplomatic studies from Nigeria, Isaac explores the intersection of African history, international relations, peace, and gender studies. His research sheds new light on post-colonial governance, racial and gender-based issues, conflict resolution, legal history, and cultural memory. He brings a nuanced transitional perspective, historical and social institutional discourse, and he is passionate about building inclusive, interdisciplinary academic communities. Our second panelist, who we hope will be joining us later, is Christian Ketter. He is an adjunct professor of law at the University of Illinois, Chicago. A former prosecutor and judicial intern on the U.S. Court of Appeals for the Seventh Circuit, Ketter has published widely in law reviews and bar journals and frequently lectures on topics including criminal procedure, constitutional law, appellate law, and jail litigation. He earned his undergraduate degree cum laude from DePaul University and his JD degree cum laude from John Marshall Law School in Chicago. Our third panelist is David Shields. He is a distinguished university professor in departments of political science, environmental studies, and legal studies at Hamline University. He is also a professor of law at the University of St. Thomas and at the General Jonas Zemytis Military Academy of Lithuania. A four-time Fulbright scholar who has taught extensively in Europe and Asia, and a winner of the Leslie A. Whittington National Award for Excellence in Public Affairs Teaching. David is former editor-in-chief of the Journal of Public Affairs Education and the author of more than 45 books and 200-plus articles on various aspects of American politics, election law, and media and politics. He is regularly interviewed and quoted in local, national, and international media on these subjects, including New York Times, Wall Street Journal, Wall Street Post, The Economist, and National Public Radio. His most recent books are Constitutional Precedent in U.S. Supreme Court Reasoning, Handbook of Election Law, Presidential Swing States, and Generational Politics in the United States. Prior to teaching, Professor Schultz served as a city director of planning, zoning, and code enforcement, and as the housing and economic planner for a community action agency. David is a former executive director of Common Cause Minnesota and former vice president of the Minnesota and South Texas chapters of the American Civil Liberties Union. Lastly, our final speaker is John Quinn. He is an assistant professor of law at Touro University, where he teaches civil dispute resolution and procedure, evidence, and appellate advocacy, and serves as the co-advisor to Moot Court. He joined the faculty full-time in 2023 and transitioned to the tenure track in 2024. Professor Quinn has been recognized with multiple honors, including the Judge George C. Pratt Moot Court Board Alumni Association Award in Appellate Advocacy, the Student Bar Association Faculty Award of Excellence, and the Law Center's Award for Devoted Service to Ideals and Purpose of Legal Education, and Professor of the Year. Previously, he taught at St. John's, Harvard Law School, and served as a law clerk in the United States District Court for the Eastern District of New York, following more than a decade in trial and appellate litigation. His research interests include law and religion, constitutionalism, statutory interpretation, and habeas corpus. Professor Quinn earned his AB and JD from Harvard and a PhD in English from Stony Brook, and he currently serves on the Criminal Justice Act panel for the U.S. Court of Appeals for the Second Circuit. I think we'll get started with Isaac.
Yeah. Good afternoon, distinguished faculty, honored colleagues, and members of St. Thomas community. Before I proceed to my discourse, I think it's highly sacrosanct, and very, very crucial to lay it bare that I'm not a legal practitioner, but I come to these, conversations, from a place, where fragility of constitutional suspension, it's not just an abstraction, of democracy. So the topic for my dialectical colloquy, is laden on emergencies of power abuses and constitutional limits Trump precedent. So in the course of this, I'll be sharing my screen for my presentation. My research addresses a fundamental faucet origo or crisis in American constitutional law. For over 2 centuries, the expansion of emergency powers during genuine crises from the Civil War was premised on executive good faith and voluntary relinquishment of extraordinary authority once emergencies passed. Trump's presidency is the first sustained attempt to weaponize emergency powers for routine political purposes, while explicitly acknowledging that no genuine emergency existed. As a result of this creates an unprecedented constitutional challenge because existing legal frameworks provide virtually unlimited deference to executive determinations of emergency circumstances with minimal procedural constraints or substantive limitation. Now, in my framework, if you notice, I was able to explore the constitutional sources of emergency authority. First, we have the Article Executive Power Clause. We have the Article 2 Commander-in-Chief Powers. We have the Article 1 Necessary and Proper Clause, which is the congressional delegations. And we have no explicit emergency clause or constitutional exceptions. Now, the absence of explicit emergency provision was not accidental. I reiterate, the absence of explicit emergency provisions was not accidental, but it reflects a deep colonial experience with British emergency powers that were used to suppress resistance. Now, the framers of this discourse, believed that constitutional structure would provide adequate faucet origo, or perhaps the crisis response without requiring explicit exception to normal governance. However, this approach places primary responsibility for constraining emergency power on Congress through legislative authority and courts, and as well through judicial reviews, rather than a constitutional limitations. My next slide discusses how Congress created executive supremacy. Now, in this slide, what I was discussing here was how the post-Watergate reforms effort that produced the National Emergency Act, they were only intended to impose congressional oversight on emergency powers, but it actually institutionalized an executive dominance by requiring affirmative congressional action in order to terminate the emergencies rather than affirmative approval to continue them. Now, for the IEEPA, Inclusion of Foreign Policy, it is to protect the interests, which means presidents can only declare economic emergencies whenever foreign governments act inconsistently with American diplomatic preference. And why the Insurrection Act of 1807? This was a broad language in Section 253, which allows the domestic military development or deployment rather, whenever president determined that in quotes unlawful obstructions makes it impracticable to enforce federal law through normal procedure. So this creates in ipso facto or ipso jure, this creates a standard that could justify military intervention in virtually any significant protest or civil disorder. My next slide, how courts enable executive overreach. Now, the bone of contention here, or what I'm trying to juxtapose here, is that the political question doctrine as established between Baker and Carr, we are able to holistically identify factors that render constitutional questions non-justiciable, including textually demonstrable constitutional commitments to some department politically, and even lack of judicially discoverable standards. Now, courts in question now routinely invoke this doctrine to avoid reviewing presidential emergency determinations, particularly in national security context. So the standing doctrine here, it requires a concrete and particularized injury that is rigid or perhaps difficult to establish when emergency actions involve broad policy determinations here, affecting the general public rather than discrete individual harms. Now, the 2019 border war emergency. One, we have the explicit acknowledgement of non-necessity. We have the congressional circumvention. We have the factual contradiction and even legal manipulation. Now, Trump's February 2019, National Emergency Declaration for Border Wall Construction. Personally speaking, I think, though I'm not a legal practitioner, but I presuppose that it exemplifies how emergency powers can be weaponized for partisan objectives while remaining technically within statutory bounds. Now, this declaration in question, it established the precedent that emergency powers can be invoked based explicitly on political expedience rather than genuine security threats. The border war emergency is constitutionally problematic because Trump explicitly undermined its legal foundation by acknowledging that no genuine emergency existed. That is a question of petito principe that must be back. It's an argument, an argumentative fallacy that borders to change called petito principe, and there has border another gen called post hoc ergo propter arc. So the National Emergency Act requires circumstances that pose unusual and extraordinary threats in quotes to national security. But Trump's statements in that regard that he could build the wall over a long period of time in quotes contradicted his standard and policies. My next slide, I was able to discuss how emergency authority was threatened. Now, under this part, we have the IEPA for tariffs, we have the Mexico tariff threat in May 2019, and we have the protest suppression. So these are patterns I was able to espouse, during my findings. So, but what I noticed is that this threat, it normalized the concept of using emergency powers as diplomatic coercion and domestic political intimidation rather than genuine crisis response. Now, for the Mexico, what I learned during my findings for Mexico tariff threat, I think Mexico tariff threat, was explicitly conditional on policy changes rather than based on security assessment. Trump announces, in fact, he announced 5% tariffs that it would increase monthly until Mexico agreed to enhance the border cooperation. Now, this represents emergency power as diplomatic coercion rather than security response. So the constitutional implications are severe because the Constitution grants Congress authority to regulate commerce with foreign nations and lay duties. But the presidential use of emergency powers for trade policy effectively circumvent this allocation. So the approach, to protest suppression during summer 2020 demonstrated the willingness to reframe political opposition as security threat, justifying military response, violating fundamental principles of civilian control, and even First Amendment protections. The next one is the Insurrection Act threat. This is the part where I was able to discuss the constitutional violation in which we have here reframing political opposition as threat, circumventing civilian authority, and even violating First Amendment principle. Now, in June, 1st of June 2020, Rose Gardin addressed warning of thousands of heavily armed soldiers to suppress protest violated fundamental American principle of civilian control over military forces. Now, the Insurrection Acts required that either state government request for federal assistance or presidential, determination that civilian authorities were genuinely unable to maintain order. But Trump's rhetoric suggested that the federal military deployment was appropriate whenever significant protests occur, regardless of whether state and local authorities requested assistance. Now, the statutory weaknesses. Now, this is very, I'm trying to showcase the critical failure of the statutory here. And one of them is the presumption of continuity. Let me just summarize this part because of my time. Now, all of these I've mentioned, these weaknesses, it creates a framework for legalized autocracy when president tries to exploit the statutory ambiguities, even while maintaining a technical legal compliances over this actually. So it's not saying that the current legal framework has enabled abuse. Current emergency powers statute contain structural deficiency that allow president to maintain extraordinary authority indefinitely without meaningful congressional oversight or judicial review. Next point is the institutional breakdown. Now, the previous president, generally exercised emergency powers with substantial difference to congressional preference and judicial oversight. Now, this created an expectation about appropriate behavior that served as important checks. But Trump's explicit embrace of expansive presidential authority, which demonstrated that constitutional norms erode when president tests system boundaries and political opposition lacks the institutional mechanism for effective constraints. More importantly, the polarization of American politics made it difficult for Congress to provide oversight because partisan loyalty often trumped institutional loyalty. How about the congressional committees that lack staff, resources, and expertise necessary for meaningful investigation of emergency powers, particularly when classified information is involved? And the last one, the fragmentation of media consumption created a different factual baseline for evaluating presidential emergency claims, making broad public consensus for constraint impossible. Lessons from other jurisdictions. Now, we should recall that the Canadian system provides different categories of emergency circumstances with correspondingly different governmental authorities, ensuring that emergency powers correspond to threat severity. Section 58 mandated a public inquiry into emergency exercise, including examination of whether emergency circumstances actually existed and whether measures taken were appropriate, providing accountability and probity mechanism absent from American practice. The Canada Emergency Act, as you could see, which I was able to discuss in my previous slide because of our time. Now, the reform proposal, very interesting. This part is very critical for reform because it's very necessary in amending the National Emergency Act to require affirmative congressional approval for emergency declaration to remain in effect beyond initial short term. Now, one of it is the 30 days automatic termination. Now, this is proposed because this is unless Congress passes joint resolution approving continuation. Now, a reform framework of this, I think, should automatically terminate emergency declaration after 30 days, unless Congress explicitly approves continuation, forcing regular legislative evaluation of whether emergency circumstances persisted or not. This second one is the 90 days reauthorization requirement. Now, I think for emergencies extending beyond initial approval, the 90 days requirement for extended emergencies, I think, would ensure ongoing congressional oversight while preventing permanent emergency authority. While for detailed, of course, monthly reporting, I think that should include specifics, action taken, fund expended, and even legal justification. And the last one, the automatic congressional hearings. It is quite a customs, which I think that within 30 days of an emergency declaration, automatic hearing would provide opportunities for legislative oversight and public examinations of executive board emergency claims. So I believe this structure would help to preserve executive flexibility during genuine crises, even while ensuring emergency powers which cannot be maintained without ongoing democratic consent. And we have the reform proposal 2, which we have, the first one is the 15 days expedited federal court review, which I believe the declaration with automatic stay pending determination, but the expedited procedure should be established in 15 days, which will allow federal high courts to review with automatic stay, preventing implementation of pending determination of whether genuine circumstance exists or not. Then the relaxed standing requirement, I think this allows congressional committees and state government to challenge declarations. Relaxed standing requirements would address structural bias towards executive authority by allowing institutional plaintiffs like congressional committees to challenge emergency declarations without demonstrating concrete individual injury. And we have the substantive evaluation standard. This should focus on whether genuine emergency circumstances exist rather than procedural compliance. I strongly believe, and I'm supremely confident that the substantive evaluation standard should focus on factual circumstances justifying emergency rather than limiting courts to procedural compliance review. And we have the presumption against emergency, which I believe when president cannot provide credible evidences of threat requiring immediate response. Reform proposal 3. This has to do with the institutional reform framework. We have the Joint Committee Emergency Power. This part have specialized staffs, expertise that would enhance investigative authority. We have the annual evaluation report, which I believe they should be charged with the responsibility of assessing necessity and effectiveness of all active emergency declaration. And we have the classified briefing authority, which I believe they should be in charge for evaluating national security emergency claims with appropriate security procedure. And we have the sub-Buhena power, which are meant for executive branch, branch document and witnesses related to emergency authority exercise and determination of recommendation. So all these 10-year sunset provisions for emergency power status themselves would require regular congressional reauthorization and comprehensive review of whether such authorities remain necessary. My conclusion is that the Trump presidency exposed fundamental vulnerabilities in American constitutional democracy that requires comprehensive reform of emergency powers laws to prevent future authoritarian exploitation of statutory framework designed for genuine crisis. Also, the reform proposals recommended in this research will serve as a vehicle which is essential to safeguard for preserving democratic governance and the rule of law in the face of executive overreach that threatens the foundation of American constitutional democracy. Let me end with this final note. The problem of intellectual community building is no lack of leadership, but leadership that is capable of transforming mentorship and democracy into sustainable project. Thank you.
Good afternoon, and thank you first and foremost to Dr. Charles Reed, to Jackie Moen, and to Anna Larson for the hard work in putting today's presentation together. Without further ado, I want to talk today to you all about the concept of textualism, specifically applied to the citizenship clause and the timely circumstances in which we find ourselves. Like all things constitutional, the best place to start when we are talking about the Constitution is the text. And a reminder that we're talking about the 14th Amendment here, certainly a product of the Civil War and the Reconstruction era amendments. The key text I want to draw your attention to is that first part boldened there, all persons born or naturalized in the United States, comma, and subject to the jurisdiction thereof, comma, are citizens of the United States and of the state wherein they reside. Well, those are 5 words that we're going to talk about today, certainly. Why are we going to do that? Well, because there's an executive order, quote, protecting the meaning and value of American citizenship that was handed down at the start of this year. It was something that that this administration had talked about 7 years earlier, however, and that might give you a little context as to why there was so much litigation from day one. They knew where this was going, and they were able to strategize with that in mind. I want to draw your attention to what is not recognized according to that executive order, and that is 2 circumstances. First, when the person's mother, and I want you to focus on that when we talk about the categories, and we're going to move a little quickly in the interest of time, but when that person's mother was unlawfully present in the United States and the father was not a U.S. citizen or lawful permanent resident at the time of said person's birth. Second, when that person's mother's presence in the United States at the time of said person's birth was lawful but temporary, and the father was not a U.S. citizen or a lawful permanent resident at the time of said person's birth. Before we get to the Citizenship Act, why the mother, really we're coming to the more modernized adage of we know who the mother is at the time of the birth, even if we don't know who the father is. For you Downton Abbey fans out there, certainly we used to care about the male bloodline, and that's why some third cousin twice removed would come out of the woodwork and be taking on property rights when there were female bloodline who could otherwise have taken it. Moving along here, I do want to draw your attention to a few things that I think do help to keep the constitutional project moving along. The executive order explained that the purpose of Section 1 was to repudiate the Supreme Court of the United States' shameful decision in Dred Scott versus Sanford. 14th Amendment comes to fix that wrong. I don't think it's a stretch at all to say that Dred Scott was the worst U.S. Supreme Court opinion. I think that's a pretty uncontroversial opinion, and I think most scholars and jurists would agree on that. The order also explains that the 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States. By using the word interpreted, I think that this executive order intentionally but tacitly recognizes the Supreme Court's well-settled role in saying what the law is and settling what the Constitution means. So moving along here today, I want to leave you, I hope to answer a few questions here. First, what does subject to the jurisdiction thereof mean, if anything? Certainly, we know it's going to have some meaning. Who's going to give it that meaning? Well, of course, the Roberts Court. Is this a simple question? Is it simple enough to say born on American soil is a U.S. citizen? As you'll find today, the answer is no. It's not that simple. Who says what? The Article 1 bicameral legislature, the Article 2 executive branch, or the Article 3 judiciary? These questions might have been a little less abstract at the days of the founding, but we've had certain administrations, Abraham Lincoln, FDR, Andrew Jackson, President Jefferson, and contemporary administrations that have treated the executive branch with such elasticity that these questions are a bit more abstract than they might have been at first blush. What's been said to date on there? Is there an answer? The answer, of course, is yes. Yes, there is an answer. The enabling clause for Congress's powers under citizenship is Article 1, Section 8, Clause 4. They have the power to establish a uniform rule of naturalization. They have done so, in fact. The Immigration and Nationality Act has long been enacted. The first, and I think the most interesting provision is the foundling provision, that children who are under 5 years old, provided that the parents are unknown, hence a foundling, they have a presumption of citizenship that unless rebutted before reaching the age of majority, they are presumed to be American citizens and do in fact achieve that. Theoretically, somebody could abandon their child on U.S. soil upon giving birth and otherwise achieve U.S. citizenship where they might not otherwise have been able to had they not reached these other qualifiers. Now, in the interest of time, I'm not going to read each one of these to you. The first one, of course, says that those who are subject to the jurisdiction thereof are U.S. citizens. Not very helpful when we're trying to answer the question of what does that mean. There's also Native American tribes, so long as it doesn't impair their property rights. That's the second category. There are categories for when someone is born outside of the U.S. And its outlying possessions, provided that there is a parent who has been physically present in the U.S. for a period of 1 year continuously prior to birth. There are three categories for those born outside of both the U.S. and its outlying possessions, where both parents are citizens of the United States and one parent had a residence prior to the birth, or one parent is a citizen who prior to the birth had been continuously and physically present for a continuous period of 1 year, and the other parent, who's a non-citizen, is still a U.S. national. The third one is that one parent's a non-citizen and the other parent is a U.S. citizen who prior to the child's birth was physically present in the U.S. for at least 5 years, at least two of which must have occurred after the U.S. citizen reached 14 years of age. Without getting into a whole rabbit hole of controversy, these are the aspects that came up surrounding the birther disputes for President Obama. Of course, the full birth certificate showed Hawaii, but that's really what the media. I don't think anybody was really taking the time to grapple with that. It didn't really matter. The birth certificate spoke for itself, but these were kind of the nuances that were surrounding that. I want to draw people's attention to some amendments that got removed. 1978 amendments. Prior to that, you had to have a 2-year continuous presence between the ages of 14 and 28, and before turning 18 years old, the non-citizen parent needed to be naturalized. You couldn't have more than 60 days of continuity of absence. This was too complicated as far as Congress was concerned, and they struck that. And in 1994, as I said, pay attention to the parent bloodline. In 1994, an amendment was made where a child is born to a non-citizen father, but a citizen mother who had resided in the U.S. before birth. This was to amplify the Citizenship Act of 1934. Thus, the current administration's executive order came in line more with those later amendments. A few key cases I want you to pay attention to, and I invite you to read if you want to get more of a handle on the history behind this. It is Justice Story's majority opinion in McCreary's Lessee versus Somerville, 1824 opinion there. The court said it made no difference whether an offspring was born to citizens or non-citizens because law enables the party to take as heir as effectively as if such ancestors had been born natural subjects. Nevertheless, the court cautioned it did not feel it was at liberty to derogate from the general doctrine of the common law without authority. The next two cases are Inglis versus Trustee Sailor Snug Harbor, and a case that was decided the same day, Shanks v. DuPont. Of course, this is 6 years later. Story concurs in there, and the question was whether the original sin of a British father might pass to his son coming out of the Revolutionary War. The court noted that there's a presumption that is rebuttable with a showing of intent that the individual sought to remain a British subject. So we get from Inglis kind of a limbo that one can remain incapable of making an election for himself for some time as the child of a non-citizen. Justice Story, of course, concurs separately to urge readers in Inglis to recall that Great Britain claimed the allegiance of all the American colonists at the time of the founding, and that the rule commonly laid down in the books was that every person born in the allegiance of a sovereign is a subject, and every person born without such allegiance is an alien, according to Justice Story, but that this ultimately turns on facts and circumstances. Now, Shanks v. DuPont, that was a different case where a South Carolina woman remained an American citizen, according to the court, despite the fact that she married a British officer. She left for England. She started a family there. She never returned, nor did she ever intend to return to America. And the court said that you cannot abandon your citizenship and become an alien simply by marrying someone else. Why? Because citizenship by marriage is no guarantee. I want to give you a sense of Justice Story's jurisprudence, because I think it's going to come up before the Roberts Court. He's already being cited to on this subject in the Casa Inc. case. In Story's eyes, citizenship was not to be confused with allegiance, and citizenship is a confluence of two things. One, birth on the sovereign soil, and two, owing to the obedience of that sovereign. It's a confluence of both of those. You need to have both, and in Story's monumental 1834 treatises, he echoed a basic maxim that accepted passers through, those who are, quote, in itinere, or on a journey. Those are not U.S. citizens, according to Justice Story. If you're just passing through the United States on your journey to somewhere else and you give birth, according to Justice Story, that's not a person who's going to be acquiring U.S. citizenship upon their birth. I want everybody to be mindful, of course, that this was before air travel. It was before the advent of railroads, automobiles, and large ocean liner travel, the means through which many American citizens came to the United States and their ancestors. Justice Story's exceptions, he said, were founded upon peculiar reasons. We have kind of unique circumstances here in the United States that form this. Those who are born on the ocean remain the subjects of their foreign lands from which they came. The children of ambassadors, if they have diplomatic immunity, that immunity passes to their bloodline. The bloodline are not born into citizenship. And third, the category at that time of enemy occupants, prisoners of war, people who have infiltrated the United States as enemies and they're waiting to strike. You know, if you think of the Nazi submarine case where they snuck into the U.S. during that time, had they reproduced under this exception, their children wouldn't have been, if they'd produced offspring, they wouldn't be U.S. citizens. The next wrinkle in citizenship that kind of creates an exception is Elk v. Wilkins. It's a majority opinion in 1884 that you had a Native American tribal member in Nebraska who had renounced his tribal citizenship. He wanted to be a U.S. citizen. The majority says no. They note presidential eligibility, so I can't help but think that that was not a thought in their minds that was more in the forefront. Really, you got to pay attention to Justice Harlan's dissent, who says Elk was paying taxes under Nebraska law, and if he wasn't a U.S. citizen, then the 14th Amendment failed in its purpose. Nevertheless, the majority opinion says he's not a U.S. citizen because he has sovereign rights of his own with his Native American tribe, albeit within the jurisdiction of the United States. The more important case that's going to come up, and this is where the court, with the executive order targeting Dred Scott as a past opinion, talking about the Supreme Court got it wrong. Well, I think reading between the lines, they're calling for the court and for the public to reevaluate Wong Kim Ark. What happened there in a nutshell is that the Chinese Exclusion Acts, an ugly moment in history, Congress had passed a law that said that Chinese persons could never naturalize into American citizenship. The majority of this court, while they do cut against partially Chinese anti-naturalization, does tacitly affirm that that was constitutional. Nevertheless, these Chinese immigrants, their offspring could not be prevented by Congress from becoming U.S. citizens because the child was born on U.S. soil. What was the reasoning for that? While the court recognized the unique exceptions to American citizenship, there was a great reliance on English common law. Now, I will say that in the 1980s, England abandoned its birthright citizenship and went to a different structure. Nevertheless, you had Lord Chief Justice Cockburn, you had the English common law maxims of protectio trahit subjectionem, et subjectio protectionem, that these were well settled concepts. If you're born on British soil, you are a British citizen. The court relied on that. It's certainly compelling to an extent, but America has its own unique relationship with subjects like sovereign Native Americans, something unique from the English structure. And here, Chief Justice Melvin Fuller calls that out. Who's dissenting with him? But Justice Harlan, who also, as I may remind you, dissented from Plessy versus Ferguson. Chief Justice Fuller notes that citizenship is irrebuttable under the American structure, and that statutes don't contemplate double allegiance, that international law is something far more complex. They cite Richard Reiser's case from 1888. It's a Grover Cleveland administration case. Long story short on that, in the interest of time, was that a German subject lived here, took his 2-year-old son back to Germany, even though he was born on American soil. When the 2-year-old came back as an adult, having been born here but lived and grown in Germany, he came back, and the Cleveland administration denied him citizenship, saying that under principles of international law, America was not your home. You were not born here as a U.S. citizen. You're a German citizen. And the Das Reichsgesetz über die Erwerbung Staatsangehörigkeit, that contemporary German treatise recognized Melvin Fuller's dissent and the Cleveland administration's reasoning as very profound, and something certainly that made its way in a very short time over to Germany as settled law. So you can see it's complex here. It's not that simple. Where are we going with this? Well, I want to give you just kind of a flavor of the litigation that immediately sprung up. It's not uniform. They're making different arguments. The Washington case says there's automatic citizenship. Born on American soil, U.S. citizen. Well, we know there's well-settled exceptions that we can see from the prior case law, but certainly that's how the Washington case that went up to the Ninth Circuit has postured itself. The Casa Inc. case has recognized well-settled historical exceptions like diplomatic immunity. The New Hampshire case, like Casa Inc., has recognized historical exceptions. The Casa Inc. case covered 680,000 members who would be affected by the Trump administration's executive order. The New Jersey case begins by saying there is no exception in the citizenship clause, but then acknowledges later in the complaint that there are exceptions to citizenship. We talked about those exceptions, of course. The Doe case also recognizes exceptions for foreign diplomats. So that gets us up to the Trump v. Casa. That's the case that went up to the Supreme Court. You probably saw it. If you didn't read the opinion, at least you saw it in the news. They didn't touch upon the merits. Why? Because the administration didn't take up the merits to the Supreme Court or the appellate court for that matter. They took up simply whether or not the injunctions were overbroad. I will say Justice Sotomayor called that gamesmanship. I can say I've defended, in private practice, I've defended government entities, and I've litigated against the current administration and the immediate preceding administration. It's common that they structure what they're going to take up on appeal. I wouldn't call it gamesmanship. I would call it just standard litigation. And certainly if it is gamesmanship, it's to be expected in litigation. You're the king of your own complaint. You're the king of your own appeal. What you take up is what's reviewed. They took up the scope of it. It got sent back down. And the courts, they did a little more math. They did a little more work. And they got to the same end result on that the injunctions were sufficiently broad. Are the merits going to return? If you read Justice Sotomayor's dissent and Justice Jackson's, they were critical of the majority for dodging the merits. We know it's going to return because certiorari has been sought in the Washington case, the absolute citizenship case, and it's going to come back up before the Supreme Court, likely then with that in mind. My argument, to cut to the chase, is that the treason clause, as Justice Kagan has said, we're all textualists on the Supreme Court. The treason clause is the best thing that ties everything together and preserves that American structure of those exceptions without making them court created. What do I mean by this? I'm saying that subject to the jurisdiction thereof means that if, when you're born on American soil, no matter how far away you go and no matter how long you have been away from the United States, if you would be bound by the only criminal statute that's in our U.S. Constitution, the one that the founders thought was so important as to include it, if you find the treason clause, it kind of ties this together. It comes up with those exceptions for foreign diplomats. It covers the exception for Native Americans that are of sovereign nations. if they take arms against the United States at some point in their life and they couldn't be deemed to have been treasonous, that is your information as to what subject to the jurisdiction thereof means. That's what I posit. I think that with some structuralism, you tie that together a little further. We know that Congress has enumerated powers to regulate commerce with the foreign nations and the sovereign Indian tribes. We get that from Article 1. We also know that the law of nations is something that factored into the founders when they were drafting the Constitution. There we see Justice Story's in itinere concept of those passing through. If you have not come to the United States, whether through the formal channels or whether on an undocumented means, if you have not come here to make it your home, but you're simply passing through, that would also factor in through that law of nations pipeline to the extent that the law of nations is referenced in Article 1, Section 8, Clause 9. This comes back to Fuller's dissent that English common law is not answering all these questions. I think the best way to answer that, certainly Lawrence Tribe says, the best way to answer what the Constitution means is to find something in the Constitution that informs that. As I said, law of nations is going to get you that concept of vagrants versus people that have come here to make it a home. It ties it up better. And I think with this court, if the plaintiffs want to succeed, they need a textualist basis. The Roberts Court is going to do its own work, and it's going to look back. It's not going to simply rely on Wong v. Kimmark, or on U.S. v. Wong Kimmark. I want to draw everybody's attention without getting too in depth because we got to move along here. But Professors Erler and Akil Amar, did a debate for the National Constitution Center, and Professor Amar, constitutional scholar, said there's no reasonable question regarding birthright citizenship. Professor Erler kind of argued that Fuller's dissent had it right and that the English common law is self-contradictory. I think that they both may be tapping into something. I think Professor Amar is right that there's no reasonable question, but that Professor Erler is correct too, that the Wong Kimmark majority opinion may not be as sound as it seems at first blush. And my answer is that there is a reasonable answer and that the treason clause is what ties it together. That type of reasoning is what makes someone subject to the jurisdiction thereof and makes them a U.S. citizen or not. I think the Ninth Circuit's tapping into something here when the Ninth Circuit is saying that the Wong Kimmark Court must have understood the phrase to refer to the United States' ability to, quote, fully subject an individual to its laws. Indeed, it is the treason clause, my argument, that separates those who are fully subject from those who are not. I think it's ironic that the Ninth Circuit concludes by citing the Roberts Court's decision in D.C. versus Heller. What do we know about that case? Is that from 1791 to 2008, we did not have a settled meaning necessarily of the Second Amendment, and that's something that we got from Heller, albeit a long time later. Nevertheless, this court does not shy away from settling the meaning well over a century later. As I wrap up here, no litigant has cited the treason clause. No litigant has made that argument. I think we're going to expect creative hypotheticals. This court talked about loud music between neighbors on the Casa Inc. case. Justice Sotomayor in the oral argument talked about whether or not a president could issue an executive order that seizes everybody's guns. Justice Jackson in her dissent talks about a Martian coming down onto the United States from outer space. So I think hypotheticals are going to be expected. I don't think it's unreasonable to hear some question about, somebody flying from France to Lima, Peru that gets emergency diverted to JFK or to LaGuardia or to LA airport, and they give birth in a terminal to octuplets, or they have to go to a hospital nearby and they give birth. Are those citizens? That's where we're going to see these nuances get carved out. That's where we may see the court, as it were, split the baby. The other thing I've seen is there's some litigants that are arguing that there are due process rights potentially for citizenship to unborn children. Post-Dobbs, I would say that that's a dangerous position to take with this court because they work in slow incremental movements. And if we start seeing rights to unborn children, I can only imagine where that might go. I close with one of my favorite quotes from McCulloch v. Maryland, that we must never forget that it's a constitution we're expounding upon, one intended to endure for ages to come and to consequently be adapted to the various crises of American affairs. I have an upcoming article in the Public Policy Journal here that politics and partisanship are two different things, but in a nation founded by lawyers, we can't expect the court to have to grapple with politics in one way or another, and that it does it best when it doesn't cross over into partisanship. We see that with Brown v. Board. We see that with Obergefell. We see that effectively with Marbury versus Madison as well. And when you look at the nation's documents, critical ones like the Emancipation Proclamation and the Declaration of Independence, from a legalistic sense, like a pleading, you get a real flavor for what these lawyers had in mind when they created our nation. Thank you so much. It's been an absolute pleasure.
Professor Ketter, thank you. And now we will turn to David Schultz. Professor Schultz, please.
And let me get the PowerPoint to come up. Just a second here. Okay, a republic if you can keep it, rule of law in American democracy in the age of Trump. There's a famous quote. Some of you have heard it. Upon the exit in 1787 from Philadelphia Constitutional Hall, someone barks out to Benjamin Franklin, "So what type of government do we have?" And he barks back with, "A republic if you can keep it." And what I want to do today is to talk a little bit about how we got to that point and how we got to the point where we are right now. What I'm going to do is provide a critique of the challenge to rule of law in contemporary American politics on the Trump administration. And I'm going to draw some parallels to the Declaration of Independence and the indictment that it has regarding King George III. But more importantly, what I'm going to present for you today is an argument that goes back 800 years, an argument that eventually takes us back to the Magna Carta, that takes us back to King John, that takes us back to a whole central concept of what the rule of law is supposed to be about. And as I would say to people, it's about fear. It's about a fear of abuse of power. And that's what we're going to talk about today. Talk about how from 1215 to 1776 to 1787 to the present, that if we think about our Constitution, it's a story about what? A story and an argument about trying to address the fear of abuse of power. American democracy before Trump, even before, I want to throw this in here, even before the Trump presidency, I would argue, American democracy was challenged. The political polarization predates him. We have enormous racial disparities. As many of us know, this law school is what? Merely a few miles away from where George Floyd was murdered. The gap between the rich and poor was already accelerating before Donald Trump. Freedom House lists the U.S. with a score of 84 out of 100, and The Economist lists the U.S. as a flawed democracy. The point that I'm getting at is that there are so many people here will say, and not just in this room, that Trump is threatening democracy. And the answer is yes. But I also want to point out that even prior to Trump, the challenges to American democracy were there. But I want to take us back in time to make my argument from a historical point of view. The Magna Carta, signed in 1215 by King John of England, laid the groundwork for modern jurisprudence and constitutional jurisprudence. Its influence on the development of rule of law in the United States is profound and lasting. The Magna Carta represents an argument that I said is nearly 800, or actually over 800 years long. It is an argument about limited government, about respect for rights, and recognition for rule of law and the importance of procedure and process. It is, as I suggested, about fear, or rather yet, the fear of abuse of power. The Magna Carta, due process, rule of law, and constitution are all intertwined concepts, all birthed at this time and refined in England and then developed in the United States. It's about a fear of abuse of power by one government, by one person, one branch of agency, or by whoever it may be. And it's about a story of what? The need to restrain that abuse of power. Again, the context of the Magna Carta, how to control and check tyranny and an abusive king. King John's refusal to cooperate or work with the nobles and the aristocrats. Note that crown, by the way. Okay. No one is above the law. Section 39, I don't need to read everything in my PowerPoint here. Section 39 is all about the origin of the whole concept of due process of law, and also, I would argue, the origin of the concept of rule of law. The idea that what? Rules have to be followed, procedures have to be followed, that there are limits upon power. The rule of law, it's about, from the Magna Carta, it represents the Magna Carta, the first written limitation on a ruler's power. It influences the U.S. system of checks and balances. It supports the idea of separation of powers, and it enshrines the rule of law. Even leaders are bound by the law. All of these are concepts that grow out of there. Due process as a concept originates also with the Magna Carta as a mandate to require the Crown to follow the rules or procedures, rule of law, when acting. Meant, again, to constrain arbitrary actions by the government. And then habeas corpus emerged indirectly out of the Magna Carta as a check upon arbitrary arrest. If we put these three together, and this is what I want to establish in my background here, if we put them together, the rule of law, due process, and habeas corpus are all interconnected concepts to limit the power of the British Crown and the government. They're all about what? Fear of abuse of power. Fear that we don't trust one person. We always, at the end of the day, say, trust may be good, but to quote what Ronald Reagan many years ago, trust but verify. Trust and make sure that we have in place the rules because we can't depend upon people to act properly. I could do, and I won't do it here. I have a lot of our PowerPoint slides that I could have interdispersed between Magna Carta and William Blackstone. Many British theorists, jurists, that talked all about the importance of the Magna Carta. For our purposes, Blackstone, English jurist, judge, legal scholar, author of the Commentaries on the Laws of England, and perhaps incredibly influential on the American founding fathers and lawyers in terms of helping to shape their ways in thinking about the British law. His principles, like I said, he talks about in the commentaries about the rule of law, the importance that even kings are subjected to the law, the rights of due process and fair trial, the trial by jury, and protection of property, and constitutional limits on royal power. Again, his influence on the framers is significant. I'll pass over the details of the slide here. The Magna Carta also inspires the American colonies directly through Blackstone, indirectly through other jurists. But think about what I'm trying to establish here. Think about the point in which we are in American history, that the U.S. in 1776 declares its independence. It inherits a British common law and legal principles tradition. Again, two of my favorite books, Bernard Bailyn's Ideological Origins and Nelson's Americanization of Common Law, talk all about this. But what we're trying to get at here is, I'm going to imagine a story for the sake of argument here. Think about where we were in 1763. The 7 Years' War has ended. We are still part of British North America. The British Crown has spent an enormous amount of money to defend us. It now, as a good mother country, wants to do what? Exploit its colonies. It imposes a series of acts, the Stamp Act, the Intolerable Acts, all seeking to try to do what? Try to get revenue out of the colonies. Across the 13 colonies, correspondence committees form, organizing their protests. Imagine, for the sake of argument, a letter. Dear George, referring to the King of England, we hope all is well. Things are not going so well back in the colonies. You're imposing all these taxes upon us without our consent. We think we should have some kind of say into it. Respectfully yours, Ben. A few months later, a letter comes back. Dear Ben, nice to hear from you, but guess what? It's good to be the king. I disagree. I can do whatever I want. Think about this. Part of our Declaration of Independence. Many of you know the first two paragraphs. When in the course of human events, it becomes necessary for one nation to dissolve its political bonds. Many of you know the second paragraph, that says what? We hold these truths to be self-evident. But what most people don't remember is the rest of the Declaration of Independence that reads like a bill of particulars. It is a statement of all the things that the King of England has done against us. It is a statement of what? The history of the present King of England is a history of repeated injuries and usurpations. And again, I won't go into all the details, but it reads like a criminal indictment against the King of England. It's about what? It's about all the things that he's done wrong, all the abuses of power, all the ways that he's done what? All the ways that he has acted unconstitutionally. And at the end of the Declaration of Independence, there is then a wherefore. Because of all these abuses, we want out. We want to create our own new government. And if we think, again, I'll pass over all some of those bill of particulars, quoting directly from the Declaration of Independence. There's no question that the Declaration of Independence, our independence from England, was premised upon fear. There is no question that when we think about our U.S. Constitution starts with the problem of politics, the problem of what? The fear of abuse of power. And that the Constitution's solution to the fear of abuse of power is what? You know the answer. Checks and balances, separation of powers, bicameralism, federalism, all of it meant to address what? The abuses of power that we saw emanating from the King of England. But now, we can look at the return of the executive abuses of power. If I had more time, and if I had more detail, what I would do now is almost do parallel quotes from the Declaration of Independence. I would do lines in terms of our bill of particulars of all the things that we thought that the King of England did wrong and of which then we wanted independence for, line them up next to Trump. And guess what? They would look almost identical to why we fought a revolution. I could walk through all these different passages, all the different things that he's done about elections, all about usurpation of power. I could talk all about his executive overreach of congressional authority. I could talk all about his attacks on rule of law, the politicalization of the Department of Justice, the delegitimations of judges. If I had sent you this PowerPoint this morning, I would have also added what? Yesterday, him saying that members of Congress who call for what? Challenging illegal orders ought to be what? Ought to be put to death. All of this is what? Attacks on the rule of law. It is about his defiance of courts. It is about all the things that he has done. And all I want us to understand here, and I can add into it what? The assaults on free speech in the press. Again, promotion of domestic division and political intimidation. Attack on vulnerable communities. Disregard for federalism, especially when he wants to send troops into places like California, Chicago, and so forth. It's about the corruption of government ethics and the undermining of neutral administration, undermining of judicial independence. In some sense, what am I crafting here? A second bill of particulars, a second indictment, a second argument, and I'm not talking about necessarily impeachment here, because I think that game is already lost at this point. But if I were to have you read the Declaration of Independence again, and I know, of course, every one of you, I know Charlie does this, every day when you get up, you start off by doing what? Your morning prayers, and then you read the Bill of Rights and the Declaration of Independence. Am I correct?
Every day.
Every day. And I know he ends the day by reading them also. If you were to read them, you would see the parallels that are here, and we could draft another one. Thus, what we get at the end, the modern threat of monarchical power. The founders designed a constitution to prevent another king, but the Trump's presidency shows how easily those protections can erode. The parallels with King George III are substantive, not rhetorical. Trump represents a modern monarchical threat requiring renewed democratic vigilance, and it also requires us to think that, guess what? Maybe a constitution that was written in 1787 for a horse and buggy era at a time when we saw different threats to power needs to be updated and changed to reflect the threats to abuses of power that we see today. And notice the crown. A crown with the seal of the President of the United States on it. Thank you very much.
Professor Schultz, thank you. We have one final presentation today, and that is Professor John Quinn from Touro Law School. Professor Quinn.
Okay, so good afternoon, and thank you so much for accommodating me in this hybrid arrangement. I speak to you from the suburbs of New York. I also appreciate I'm all that stands between all of you and your weekends. So while I have some sort of heady material, I will stick like glue to my timed prepared remarks. So my subject today is the tradition half of the Dobbs History and Tradition Test, and it's part of a much larger, ambitious project that re-examines that behemoth through the lens of culture and narrative in an effort to say more fully what it really means. The narrative materials include literary abortion texts, the American Gothic aesthetic, of which I argue they are a part, and that's my main topic today, as well as materials such as the biblical narrative of Lot's wife, a nameless mother and wife punished for a never fully understood choice that's beyond my scope today. So I want to say this is no sleight of hand to exploit the infinite possibilities of, quote, law and projects. I believe I have permission from two sources. The first is Robert Cover's famous Nomos and Narrative, unofficially considered the most cited law review article of all time. I don't know who keeps the numbers, but he teaches that law is not merely a set of rules, but a dynamic, creative process that unfolds within what he calls a nomos, or normative universe. And for him, culture, and especially narratives, are the mediums through which legal meaning is made. So his large word is jurisgenesis, is his name for this process, modeled on rabbinical hermeneutics, which engages black letter law, also known as halakha, with cultural narrative, or agada. So my project could be called this, an effort in jurisgenesis. Much less abstractly, I would say my other permission comes from Dobbs itself, and so my project is not interdisciplinary, as I take Dobbs on its own black letter terms. And by this I mean simply that tradition, a word that plainly incorporates cultural material, is now constitutional law. It is one half of the two-word test, which is all we have for whether unenumerated rights exist. And although elevating the term to this stature, the court has neither defined it nor cabined its potential reach. And let me briefly just support that assertion. In the 100 pages that comprise the majority, concurrences, and dissent in Dobbs, the term tradition appears 47 times. A very few of those uses suggest that it might mean simply legal precedent or stare decisis. And certainly the court exploited this sense of it to assemble its appendix of obsolete state abortion statutes. But we absolutely know that the term tradition cannot be simply a synonym for stare decisis or legal precedent, since, of course, the court used that test to break with stare decisis and, of course, to overturn precedent. The predominant use of the term tradition in these opinions, either in the plural or paired with the adjective American or our nations, plainly invokes the term's common meaning, culture and cultural inheritance. And despite the case's historic significance, the court did not seize the moment to put any more meat on the bones of what this very open-ended term, on which the fate of unenumerated rights now turns, means. So the major scholarly critiques of this test, of course, are no surprise. History, they say, is a bad test because history can be read selectively to advance a political agenda. And tradition is bad as a test, both because it looks backward, which is a death knell for anyone who believes in living constitutionalism, and it's also normative in that it carries this implicit moral judgment about what kind of past is worthy of constitutional protection. Doctrinally, I agree, even if I do not share the no less obvious politics of the scholarship. And in a separate part of my paper, not today's talk, I do argue that even if you applaud the protection that Dobbs affords fetal life, Dobbs is still very bad law. I see a through line from Dobbs back to Buck v. Bell, almost 100 years old, never officially overruled, and sort of an inverted twin of Dobbs, which upheld a state law that allowed the involuntary sterilization of the feeble-minded. So 100 years ago, it was the state's interest in discouraging reproduction, and today in Dobbs, it's the opposite that triumphed over claims of choice. Dystopian social engineering is always bad constitutional law. But returning to my focus today, the legal debate about abortion, as anyone can observe, and I agree, is at an impasse or a discourse of exhaustion, right? What is there left to say? Further, I would say, despite or even perhaps as evidenced by the graphic medical details set forth in the court's partial birth abortion decisions, I would say legal abortion discourse has almost grown desensitized. And so I stepped outside the law to examine how America's literary imagination, which speaks other than in the mode of legal argument or medical textbook, treats this subject. Let me just add there, vast cultural materials already do participate in the abortion law conversation. Quick look at the briefs cited in any abortion case, fields of medicine, religion, and economics, all cited to the court. Most strikingly, there's even a body of materials called voice briefs. And these are statements of women who've had abortions expressing either regret or gratitude. And yet, I submit there is still both room and a need for the narrative and symbolic materials that are my subject, which I think are of a different order. So what I found as I went snooping around is that despite the highly visible public face of abortion advocacy, abortion literature was really quite hard to find. I would go so far as to say it was in the shadows, margins, and back alleys of the canon and of literary scholarship. With no MLA category for abortion literature, even decades after Roe v. Wade, I felt my search was not unlike that of Dewey Dell searching for abortion-inducing drugs in As I Lay Dying. A rumored reference here, a footnote there. The first copyrighted and probably earliest American literary work about abortion is Eugene O'Neill's one-act play titled Abortion, written in 1914, not long before Margaret Sanger made birth control part of American discourse in the 20s and 30s. It's a melodramatic play whose tragic figure, Jack, a privileged Ivy League student, commits suicide after learning that the local girl he impregnated died from the botched back alley abortion that his wealthy father had arranged. Abortion is also the unnamed topic of debate between Jig and the American in Hemingway's Hills Like White Elephants. It appears again in Dreiser's American Tragedy, Hansberry's Raisin in the Sun, Louise Glick's early poems, The Egg and the Wound, Robert Lowell's poem, The Fetus, and Gwendolyn Brooks's The Mother, just to name only a few of the more than 50 works in my necessarily incomplete compilation. Abortion in these texts resides in a vastly different register than in Supreme Court decisions, a terrain laden with ambiguity, secrecy, unease, and symbolic density that legal texts do not and cannot name. Turning back to Dobbs, I draw on a key insight from my study of those works, which is that each drew upon what I call a common body of rhetorical strategies, simply a way of writing that is identifiable as the American Gothic. This similar aesthetic evident in these works arises, I suggest, not through conscious influence, as much as from the subject of abortion itself, which I'm going to argue is a quintessentially Gothic concern. So the Gothic is not merely this stock idea we have of ghosts or B-movie horror. Rather, it is considered a way of writing and has been traditionally understood as a way of confronting that which we fear and cannot speak of directly. Familiar Gothic tropes in English literature include the heroine trapped in a castle or the madwoman in the attic. Now, one can readily cast the womb as a venue of Gothic entrapment, with abortion as the escape from male invasion. My focus is a more nuanced sense, however, of the Gothic in what has been coined the American Gothic, a title consciously borrowed by critics from Grant Wood's famous painting. A key theme in these American Gothic studies is that what is most horrifying, and therefore what we most seek to repress, or repress when we try to confront and write about it, is not the stock material of English Gothic, but what they call middleness or in-betweenness, and a series of related words, unstable zones, interstices between categories. And this is whether those categories are light and dark, reason and irrationality, or life and death. The particular American middle place or liminal zone that's the focus of these studies is the sort of unstable tension between what we can loosely call the American dream and its dark underside, the social and human costs society pays for that progress, as well as our anxieties about those costs, all of which scholars appropriately see as a legacy of the first American settlers' initial sense of both terror and wonder at the frontier, and in the larger cultural tension between Romanticism and Enlightenment in America. Certainly, abortion can be situated along or in that zone of cultural tension. Middleness, of course, summons abortion's corporeality as well, and powerful language in the work of cultural critic Julia Kristeva. In Powers of Horror, she describes the concept of abjection, which is a throwing off or a rejection or repression, and it's the result of simultaneous attraction and repulsion toward basic but repressed bodily realities like death, blood, waste, and significantly, childbirth and its variants. The point of origin for this concept of abjection and the deepest terrors, Kristeva posits, arise at the unstable boundary, half inside and half outside the womb. Her words, not mine. Now, of course, that is exactly where abortion law left the fetus before Dobbs in the partial birth cases. This kind of abjection or repression surfaces in American Gothic scholars' interpretation of the Grant Wood painting, whose title they've conscripted, which they read as visual shorthand for repression. One scholar, David Mogan, for example, writes, "The stern Midwestern preacher farmer and his daughter, the stolidly pastoral iconography, the rigid lines of the bodies, and the pitchfork with its hints of repressed violence are all vigilant emblems of American ideals that also create an atmosphere of ominous sterility as they glare upon all that does not fit into their ordered landscape, all weedy chaos, misty shadows, and riotous emotions." Another critic writes, "The painting's flatness conceals the secrets of the prairie and may conceal a haunted heritage with a pitchfork that can do more than toss hay." This ordering of the untamed, of course, has long defined American culture, and it appears in what I would consider the coda or tail to the history and tradition test. To exist, unenumerated rights must be implicit in the concept of ordered liberty. These ideas surface in the defining text of the American Gothic literary tradition. In the famous Custom House section of the Scarlet Letter, Hawthorne describes his writing room as being between two opposing sources of light and distorted by a mirror, as a place of gleam and shadow where ghosts might enter. Charles Brockden Brown's early work, Wieland, locates terror in the confusion between disembodied voices and actual ventriloquism, while his next novel, Edgar Huntley, explores the liminal state of somnambulism. And here I just want to make a side note. I fast forward 200 years Suzanne Lurie Parks, the playwright, had a very provocative off-Broadway play, Effing A. That's how it was. And it was a reimagining of the Scarlet Letter, in which the banished but frequented abortionist wears the scarlet letter A. And certainly that exemplifies how abortion readily inhabits Gothic terrain. A sort of second side note, just my ears are tuned to this. If you listen to the oral argument in the Dobbs case, the very first words out of the mouth of Mississippi Solicitor General Scott Stewart are, "May it please the court, Roe versus Wade and Planned Parenthood versus Casey haunt our country." Back to my main thread. So in yet another thread of my paper, I take up the very delicate subject of the fetus itself as quintessential Gothic figure. The publication in the 1960s and again in the 2000s of graphic fetal photography collections capture the deep representational uncertainties that parallel the moral debates. The fetus looks, at various stages, recognizably human, distinctly not, and as something in between. The captions exacerbate the uncomfortable ambiguity of the photos with references to tadpoles, pigs, and other mammals. The fetus becomes both a liminal figure and a type of grotesque or feared monster within. Think Jekyll and Hyde, Frankenstein, Ridley Scott's 1979 thriller Alien. And finally, we come to Freud, the illusion in my broad title, Tradition and its Discontents. His ideas about the uncanny have an extraordinary capacity to help explain what makes us so uncomfortable in talking about the fetus and abortion. In the German, the uncanny, das Unheimlich, is literally the familiar, or Heimlich, made unfamiliar, and is a paradox. It is the unsettling feeling that arises when something familiar becomes strange, or when something secret and hidden comes to life. Freud's key examples are walking in circles, in a fog, or in the woods, and continually coming back to the same spot. And, very resonant with fetal imagery, he describes the discomfort we feel when a doll or an automaton seems to look at us. We are anxious, he says, when we even temporarily cannot be sure whether something apparently lifeless might be animate, or vice versa. Skeptics will, of course, ask about my project. Does any of this help decide cases? And I'm quoting colleagues where I work. And so my answer is, I'm not sure. If I have to offer something doctrinal, I will step right up and say, stop abjecting, confront the ultimate fact ambiguity with the tools the law has long used to resolve basic questions of fact, evidentiary presumptions, and burdens of proof. Presume the fetus to be a life and allow abortion only if it is proven not to be beyond a reasonable doubt or clear and convincing evidence or some other burden of proof, or vice versa. But the court has steadfastly refused to go down this road, holding to Roe's famous declaration that we need not decide the difficult question of when life begins. But I would say, even if my work does not help us decide cases, does it help us come to terms with what they mean? And I think yes. For starters, it helps me see and say that despite the very public face of pro-choice advocacy, abortion is still very much a part of America's subculture, or in the vocabulary of Dobbs, I would say sub-tradition. Tradition, therefore, is either the most inappropriate of tests, because the tradition of abortion in America cannot be tied up neatly in a presentable doctrinal bow. Or tradition is the ideal test if the word is not morally or politically cabined. All of this also helps us see, or helps me say, that Dobbs is in a sense the pitchfork. It's repressing the weedy chaos, misty shadows, and riotous emotion of abortion as a subject and of the chaotic consequences of its ruling. And all about the subject that does not fit into its well-tilled rows of obsolete abortion statutes. I will close with by invoking critic Northrop Frye's famous concept of there being three types of language. One type is everyday speech, conversation. The second is the formal language of practical communication, where we value transparency. This would be the language of science, journalism, scholarship, and the law. His third category is what he calls the language of the imagination, and this would be both the use of figurative language, metaphor, symbol, and architect, but also a register that engages higher human states, such as freedom, creation, and vision. And on this view, I want to suggest that Justice Douglas in Griswold, the contraception case, wrote more truly than he knew. When he spoke of constitutional penumbras, literally shadows, and emanations, I think he was unwittingly using the language of the imagination inside a legal text. Some provisions of the Bill of Rights are written with the density of poetry, even of a sacred text, and so are ideal candidates for cover-like Juris Genesis. I think Douglas's imagery evokes Hawthorne's writing room of gleam and shadow, and certainly resonates with the Gothic middle places I've been speaking of. So I want to say he may be right. Gothic interstices may indeed exist within the constitutional text itself, and it may be in those interstices between constitutional shadow and constitutional light that whatever the Constitution has to say about abortion may lie. Thank you.
Professor Quinn, thank you. Just a few observations, a few questions for our panelists, and I'll be brief in interest of the fact that we are like 20 minutes overdue. But I'll begin by pointing out Isaac, Dr. Adelekun. I'm going to begin by looking at the statutory regime you looked at from the 1970s, the National Emergency Act, the IEEPA, and point out that those statutes seem to rest on a different anthropology, if you will, than we had at the time of the founding. At the time of the founding, our anthropology was a concern with the diffusion of power, that we wanted to spread power between and among the different branches of government because we did not trust the holding of power in a single set of hands. And I am personally surprised that these statutes were passed in the middle 1970s, shortly after the Watergate crisis, because it would seem to have been a time of anxiety and apprehension regarding trust in the executive branch. But nevertheless, these statutes placed a great deal of trust in the executive branch. I'd like it, if you could, to comment briefly on those contrasting anthropologies between an anthropology that is deeply mistrustful of concentrated power and one that quite surprisingly reposes a great deal of trust in concentrated power. Professor Ketter, the question I have, and this is more an observation than a question because you come out much the way I do on the question of birthright citizenship, is that if the Supreme Court should take steps to overturn a Wong Kim Ark, the practical problems posed would be enormous. We would be the word fails me. De-citizenizing, is that a word? The many millions of people who seem to have citizen status. And if we mean to apply a reversal of Wong Kim Ark prospectively only, then it begins to look arbitrary. And so birthright citizenship provides us, I think, with a bright line test that has many advantages, although, of course, the Supreme Court will have the final say on this. Professor Schultz, I would like to connect your paper with my comments on Dr. Adelakun's paper, and that is we have these emergency acts in the middle 1970s that place tremendous trust in the executive branch. And why this trust in the middle 1970s? So I find that historically anomalous. I find it something worthy of investigation. It's a puzzlement. And Professor Quinn, you capture extremely neatly the tragedy, if you will, of abortion. Your sense of middleness connects, I think, with the tragedy that people feel. And when confronted with the issue of abortion, we began this morning's sessions talking about the human person and humanities within the law. And Professor Quinn, you've brought us around full circle, I think very deeply, very profoundly to exactly those questions now at the very end of our presentations. So if you will, I'd like each of you to, if you could, respond briefly to these observations. Thank you.
Thank you for that beautiful question. I think the mid-1970s you raised, were not a random moment. They were the most severe constitutional legitimacy crisis in modern American history. So Congress passed the National Emergency Act and eventually the IEEPA because the presidency had been exposed in a way the country had never seen before. So there are three seismic shocks collided at that time. First, as I've mentioned in my slide, was Watergate shattered executive credibility. It's a case of rep ipsa loquitur, of course. So Congress suddenly saw that the modern presidency as an institution is capable of unchecked abuses. And the second I would also like to raise is that the Pentagon Papers revealed an entire hidden architecture of executive decision-making that operated outside democracy oversight. And the third was that the Church Committee exposed the decades of secret surveillance, covert action, and even intelligence abuses, which were able to carry it out without statutory limits. So this kind of revelations, struck at the core of American democratic self-understanding. So when Congress moved in the 1970s, it was not innovating, it was reacting. So the National Emergency Act and the IEPA were attempts to discipline an executive branch that are proving itself capable of acting unilaterally, but secretly and even often deceptively. So, but here is the critical point I'm trying to make here. Congress chose procedural control rather than substantive constraint. So they created a reporting requirement that led to probably termination of mechanisms and even notification procedures, but they never defined what actually counts as an emergency. So they assumed that future president would act in good faith. So this is where the anthropology of power becomes relevant. So anthropologically, when a system relies on norms instead of enforceable rules, leaders will inevitably test the boundaries, especially if the institutional environment hesitates. So the real surprise for me is that Trump pushed emergency powers. That is, the American system still operates in a cultural expectations here of executive restraint decades, even after learning that restraint cannot be assumed. So in other words, the mid-1970s created a legal framework, but Trump revealed its intellectual flaw. The statutes were built on trust, not structural protection. And when trust collapses, authority expands, exactly as both law and anthropology would interpret. Does that make sense?
Yes, it does. Thank you.
You're welcome.
Professor Ketter.
Yes, I like your analysis. I think you're right on the mark, and certainly lines up with what Professor Akhil Amar was saying, that there's no reasonable question here. I think having dove into the history on it and the case law, there isn't a reasonable question. But one thing we know about this court is that they're not shy from doing their own work. But that it seems that as though the Chief Justice is always looking for the best way to tie it all together. And so I think that you can accomplish both of that. I don't see an overturn of Wong Kim Ark, but I don't see a simple check mark, check in the box saying, well, Wong Kim Ark got it right. I think we're going to see a little more nuance and maybe kind of carving out certain exceptions. They seem to be very reliant on Chief Justice Marshall's jurisprudence as well as Justice Joseph Story. I think we're going to see that maybe that in itinere analysis may be kind of carving in the middle. What does that do going forward? I think maybe you see some people that might have had citizenship under former structures, maybe accepted going forward, accepted that is. Maybe not. Maybe they don't go that route. Maybe it's just as simple as saying, Wong Kim Ark, the holding was right. Here's our work that's saying why that holding was right. Certainly, I think they're going to be going for a short opinion on this one. It's a complicated subject, but I do expect that we'll see something that looks at the history again.
Professor Schultz.
Sure. Hold on a second. We on? Okay. I'll start off by simply saying we blew it. Congress blew it. All right. Think about after Watergate, 3 of the big reforms: War Powers Act, National Emergencies Act, and the 1974 Budget Impoundment and Control Act. All 3 of them were premised upon what? Efforts to contain presidential power and to try to address the abuses of the Watergate era. But at the same time, the abuses of the Watergate era grow from what basically the New Deal era. It was at a point where Arthur Schlesinger Jr., the historian, had already worried about what? The rise of the imperial presidency. And the reason why I say we blew it, all 3 of those acts relied upon what? They were at the one hand saying we have to address abuses of power, but what did they rely upon? The good faith of the president to be able to comply with them. We just blew it. Congress blew it completely. And I would argue that now, that the bigger problem is not necessarily presidential abuse of power, which it is. It's what? Congressional basically giving up of its power. It is also the court giving up of its power. So to a large extent, those 2 branches have failed to perform the duties that they were supposed to perform as envisioned by the framers, is to provide the viable checks and balances and separation of power they were supposed to do. So I'll just simply say, they blew it.
And Professor Quinn.
Well, thank you. I want to say briefly, I applaud your bravery and courage in using the word tragedy to describe abortion, because I find myself never sure what it is appropriate to say and what audience I'm in. If it's a mere medical procedure, then certainly it's not tragedy. And so, and it's a subject that has occupied me for decades. I've been trying to figure out a way to talk about it. And I think of, there's a famous Raymond Carver short story, what we talk about when we talk about love, right? And I always think, what are we really talking about when we talk about abortion? And so, again, I appreciate your attentive and perceptive response to my work, and thank you.
No, thank you. And I'd like to thank everybody who helped make this a successful event. I'd like to thank our speakers, Professor Quinn, Dr. Adelaikun, Professor Schultz, the speakers we had on Professor Ketter, the speakers we had on our earlier panels. I'd like to thank Denley Wenner, Anna Larson, Jackie Moan of the JLPP, the Journal of Law and Public Policy. I'd like to thank the support staff who helped set things up in our atrium and and provided us with a wonderful lunch and all of that. And we are looking forward to a great weekend. We've had a great, successful event. Thank you all. In April 10th, we will be doing another symposium on agriculture policy and food supply agriculture policy. And so you're all welcome back then, and thank you all. Thank you all.